Well, good evening and happy Wednesday to all of you. Happy middle of the week. We have made it to the midpoint of another week. I cannot believe that it is already October 24th. I feel like if you asked me yesterday what day it was, I would say, is it 2023 yet? Just saying. That's kind of the feeling I've got right now. So here we are again, Wednesday, October 24th. Is it Tuesday? Is it Tuesday? It's Tuesday. It's Tuesday. It's Taco Tuesday. My brain is all over the place already, folks. It's already all over the place. It's Tuesday. It's Tuesday. My word, Rob. You can do this. You remember what day of the week it is, hopefully. I mean, you have court on Thursday and Friday. So, good evening to all of you catching this live. And to those of you on the replay crew, we love the replay crew. Good day, good morning, good afternoon, good evening, and good night. I hope that you guys have a splendid week going for you. I hope you are getting all of the things done that you need to and accomplishing all of those things. So today and tonight, we are continuing our recaps of the Take Care of Maya trial. This is the case of Maya Kowalski, rather Jack Kowalski, etc. et al., which is Jack Kowalski, the estate of Beata Kowalski, Maya Kowalski, and Kyle Kowalski versus Johns Hopkins All Children's Hospital, JHATCH for short. This case involves a child who, Maya Kowalski, was previously diagnosed with CRPS, complex regional pain syndrome. Maya Kowalski presented at All Children's Hospital, JHATCH, on October 7th of 2023 with acute abdominal pain and that prior diagnosis of CRPS. In the resulting days, the hospital came to question that diagnosis, and the treatment of the hospital is the subject of this particular lawsuit. On October 13th, a shelter order was entered by the court in Sarasota County, Florida, that essentially sheltered Maya at JHATCH for continued observation and treatment while the court was resolving what to do in an allegation of medical abuse by Beata Kowalski as to the child, Maya Kowalski, who was 11 years old at the time. Over the next 87 days, Maya Kowalski remained sheltered at Johns Hopkins All Children's Hospital until January 6th, when the parties appeared before the court, and Maya Kowalski was not permitted at that instance to speak with her mother. Her mother, Beata Kowalski, unfortunately, the very next day, ended her own life. We are discussing a lot of complex medical issues, complex regional pain syndrome, and other diagnoses of Munchausen's by proxy, fictitious disorder, conversion disorder, things that are highly sensitive. So I have a running banner on these streams so that people know when they are coming in and joining that they are entering into some sensitive subject matter. That said, some rules for the chat. Because we are discussing things that are remarkably sensitive in nature, I ask that the chat please remain focused on the testimony being offered by the witnesses, the arguments being offered by counsel, and not make comments about the witness's appearance, their name, etc. We're trying to be respectful here. This isn't the Wild West, and we're going to be respectful about what we're hearing. And that's just kind of one of the rules for the road. It allows us to keep this video up on YouTube. You might notice that there are certain words that you cannot put into chat. For example, the big S word relating to Beata Kowalski's decision to take her own life. That's there because YouTube will go and review the comments, and the video has a risk of being taken down, and the information that we're discussing is too important to be taken down. So that's why those rules are in place. Who am I? Why are you listening to this guy on the screen? Hi, my name is Rob. I've done this introduction of myself for the past several days. It feels like weeks, and it gets more and more awkward every time I do it. Hi, I'm Rob. This is my channel, Law and Lumber. I'm a practicing domestic relations litigation attorney in the Commonwealth of Virginia, and I have been so for the past more than a decade. So this particular case has a very interesting overlap in between domestic relations litigation, medical malpractice, and complex medical issues. So I've been trying to give recaps of the day's testimony and evidence every single evening to try and keep people caught up to speed in a case that is fraught with danger. And when I say fraught with danger, I mean there are so many complex issues that it has been like walking a tightrope from either side. Not getting into the DCF removal proceedings because DCF and the hospital, when they're engaging in that investigation with DCF authority, is immune from litigation in that regard. This is a $220 million lawsuit against the hospital. And because of that, a lot of eyes are tuned in on this. So, with that warning in mind, let's go ahead and get into some of the testimony from today. I know that we left off yesterday with testimony. Sorry, one second. Just wanted to see something in the chat. We left off yesterday with testimony from Dr. Jennifer Katzenstein. I think I said that right. Hopefully I said that right. And Dr. Elliott. I wanted to try and recap some of that, but I unfortunately can't because the testimony today was from two witnesses that I think are the hospital's most significant witnesses thus far in the case. So I want to make sure I'm giving ample coverage of that to have dialogue and discussion on what was testified to today, because the defense is starting to roll out their case. And the defense's case gained traction today. So we'll be able to break some of that down. Let's go ahead and get into it. Oh, programming note. Programming note. You guys see the comment on the screen. That is my friend Spidey from the behavioral arts. Spidey and I have done several videos in the past where we will kind of go over testimony and we'll discuss some of the dialogue that's being addressed on screen, as well as some of the behaviors that are exhibited by the person testifying. Spidey does great coverage of body language and analysis. He is trained in psychology. That's his background, but he also, oddly enough, is a magician. So he's very attuned to, behavioral analysis. If you guys want to check that out, please go do that. I don't need to promote his channel. He has over 800,000 subscribers. I think he's nearing in on 1 million pretty quickly. Oh no, I think he's over 900,000 subscribers. So he's nearing in a little bit more than almost 1 million. Why am I pulling this comment up? One, he's a really great friend. Two, there were depositions by Sally Smith. And the depositions, you guys might recall, I had certain reactions to. Sally Smith, we anticipate testifying on a Thursday. Rather than try to run something out in the middle of trial, Spidey and I have been talking about this. I sent him some clips from the deposition. And we're going to keep an eye on what's being testified to on Thursday when Sally Smith takes a stand. And on Saturday, on this coming Saturday, that is what? What's the date, Rob? Come on, what's the date? Saturday, the 28th of October. Spidey and I are going to do a joint live. What does that mean? That means that if you are a subscriber to either the Behavioral Arts or to this channel, Law and Lumber, you're going to see 2 live videos pop up at the same time. It's because we're sharing a live stream. We can do that no matter which way you chat, whether it's to Spidey's live or to my live. You're going to be able to interact with both of us on screen, and we're going to go through the behavioral analysis of the testimony from Dr. Sally Smith. So that's kind of a little bit of a warning. He and I just solidified that within maybe the 60 seconds before I went live. So that's why we were a little bit late this evening, because we wanted to make sure we solidified that and I could get that and brought that up. But Spidey, thank you for the very kind comment. That was the humblest intro ever. I would add greatest lawyer on YouTube who ever existed and will ever exist. Thank you, Spidey. So that is what you have to look forward to on Saturday. But today, we're talking about what happened today. And as I have been doing, I'm going to continue to do, which is to highlight little fun parts of the trial before we get into the heavier subject matter. And a lot of you guys have noticed that young Miss Samantha Lawrence, who is the younger attorney in the courtroom, has been on the forefront of a lot of my commentary because she passed the bar while this trial has been ongoing. Someone asked me a question earlier today about how can she have just passed the bar and be in court and saying these things. There's usually a ceremony after you pass the bar where the Supreme Court of the justice of the Supreme Court of whatever state you are in swears all of you in about 1.5 months or 2 months after you get your bar results, right? So you get your bar results, and then several months later, Supreme Court justice comes in and says, I hereby bestow upon you the ability to practice law in the courts in the state of blank. Okay. But when you're in the middle of a trial practice, or when you are an active practicing, and you're in an active practice and your litigation team is relying on you to contribute as an attorney, sometimes we have to take things out of order. So sometimes we get special exemptions where we can get sworn in front of a particular judge we're appearing in front of. That's what happened with Ms. Lawrence. So Ms. Lawrence is a barred attorney in Florida and has been sworn in the court that is hearing this particular case. And I have been very interested and happy in seeing her presence there, and the fact that she's getting an ever increasing role in a trial that is very likely to be at the forefront of her career for a long time, just because these things have such impact on how you continue litigating and who you become as an attorney. So without further ado, let's hear from Ms. Lawrence giving the introductions of the parties. Yeah, let's go ahead and let's go ahead and hear from it.
At all versus Johns Hopkins All Children's Hospital. Starting with the plaintiffs, let's take appearances, please.
Samantha Lawrence on behalf of the plaintiffs with Nick Whitney and Greg Anderson.
Howard Hunter on behalf of All Children's Hospital with Ethan Shapiro, Pat Crowell, David Hughes, and Chris Altenburn. Our corporate representative today is Dr. Richard Elliott.
Thank you. Can I see the attorneys up here, please?
So judge calls sidebar immediately, but even so, we got to hear from Ms. Lawrence again, and you saw the little smile on the judge's face. I think it brings a little happiness to him to see a young member of the bar practicing in front of him that I am sure he hopes will continue practicing in front of him for years and years to come. But that wasn't her only involvement in the case thus far. So we had an additional comment today that I caught. I don't know if a lot of you did. So 547. Let's see if we can't find that particular timestamp. So 547 and oh no, is that not it? I thought it was. Wait a minute. Why is my timestamp off? 547:44. That's what it says. Their stream is updating and being funky. Hang on. I have to find this. This is important to me. Maybe it's this one. Bear with me one second. We are professionals. We are professionals. We know how to do this. Think. Sometimes. Yes, it was when they returned from this break. Just find the right moment. Oh, long crime stream did update. Okay, hang on. I got to back up. It's not this one. Give me 1 second. I'm going to find it. It's important to me. It's important to me.
Please be seated, members of the jury. I want to confirm while you were away, you did.
Nope. This cannot do. This cannot do. Rob, this cannot do. This must be remedied immediately. Because I will be, no way am I allowing this to go forward without calling out a really cool moment in court. Okay, sidebar. Exit sign.
Please be seated, members of the jury.
Nope. Here we go.
You're going to get to do what?
Here we go.
Miss Lawrence, you're up. Come on. Are you going to get to do one of the witnesses? Okay. Okay, the doctor's back. Doctor, in front of the jury, I'm just going to remind you that you're under oath. Okay.
That was a fun moment. That was a fun moment where you know, in these trials, we have to focus on some of the levity that we get. And that was a fun one. Mr. Anderson was late coming back to court. Ms. Lawrence was sitting there alone in the courtroom as the only attorney on the plaintiff's side. And the judge gets the opportunity to kind of look over and say, Ms. Lawrence, all right, it's your case. It's your case. And then asking, are you going to be able to examine one of the witnesses? And that gave me a thought. The plaintiff is running short on time. They're going to have to pass on a number of witnesses. And there's going to be some planned passes where a witness is not going to testify too strongly for the defense and the plaintiffs get to stand up and say, no questions, Your Honor. I kind of want to see Ms. Lawrence stand up and say, Your Honor, we have no questions for this witness. That would be cool. I know it's high stress. I know it's probably not going to happen, but it would be great if it did because you know what? Why not? All right. So let's go into the first bit of testimony that I wanted to cover today, which was a little point here and there. And I do want to make a comment before we get into the substance of the testimony today. A lot of people have been very invested and interested in this case. And because of that, when I do these recaps, there's a lot of chats that come in, a lot of chats that are very generous super chats. You guys never, ever have to super chat this channel. I promise you, I try to keep an eye on the chat as much as I can. And I try to pull comments up when I can, whether it's a super chat or not. Never feel like you have to send anything. Please. But for those that are sending in super chats, if it's not a question, I do have to pull them up. You'll see them at the bar across the screen at the bottom. I have to pull them up because at the end of the day, I have to get back to actually practicing law tomorrow, and I need to make sure that I land this stream in a time that allows me to go and do that for my other clients and cases. So thank you guys for all the contributions that you guys give to the channel to allowing this to go forward and for the interest you've shown in this case. And importantly, the respect that you have shown in the chat when discussing these sensitive issues. So our first witness today, and I will swoop to get there. Our first witness today is Dr. Lowry. So swoop. See, just makes the testimony better. So Dr. Lowry is testifying by deposition. And I wanted to pull this up because I wanted to make a point when we hear the beginning of this, because Mr. Hughes is doing the direct examination in this one. And all of this time goes towards the defense's time, the hospital's time. But I wanted to make a point about how important the depositions are and how important conduct of the attorneys during the depos is.
My address of work.
Doctor, will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give today be the truth, the whole truth, and nothing but the truth?
I will.
Dr. Lowry, can you please state your name and professional address for the record, please?
My name is Kelly Lowry. My address of work is 225 East Chicago Avenue, Chicago, Illinois, 60611.
And where are you presently employed?
And Robert H. Lowry Children's Hospital of Chicago.
Okay. And was that the same place you were employed back in July 2015 when you encountered the Kowalski family?
Yes.
Okay. Well, what is Lowry Children's Hospital?
It's a pediatric children's hospital.
Did you review anything in connection with preparing for today?
Yes.
What did you review?
My notes.
And those are your Lowry Children's notes?
Yes.
Can you give me the benefit of your training and education from the time that you graduated from high school or from college through any types of advanced training or degrees you have in your chosen field?
Sure. I received my bachelor's at West Virginia University. Following that,
H&P here. Do you see where it says Elizabeth A. Byrne, MD?
yes.
And if a pediatric attending physician wants psychology involved, can you walk me through how in 2015 they would get someone like you involved in the workup of a patient?
Yeah, generally the process would be that the physician would put in an order for a psychiatric consult, and a member of the psychiatric consultation team would receive that consult and do an evaluation and make treatment recommendations if applicable. It's the general process.
Continuing here with Dr. Burns' history and physical, which can be found on LCH 140 through LCH 145, I wanted to ask you about a few entries in there and see if you can tell me what the significance of these entries are in your field as a pediatric psychologist. On page 143 in the impression section, Dr. Byrne notes here, quote, "Her exam is not necessarily consistent with her history, which raises concern for a psychiatric component to her presentation, and specifically conversion disorder." Do you see that?
I see that.
Okay.
Okay. That might have seemed like a nothing, like a Rob, why are you playing this? Why are you playing this one clip? Let me explain kind of how these deposition designations work. We've seen a lot of them during this particular trial. So the deposition designations are depositions that were taken prior to the actual trial itself. This is a deposition that's taken by either party, either the plaintiff or the defendant, that's calling the witness to testify, and they know that they're not going to call them at trial, or perhaps they're unavailable at trial when the trial date comes. The deposition oftentimes is videotaped because in the eventuality the witness is unavailable, you want to be able to play the videotape. During depositions, there is no judge present. I've called it before the Wild Wild West. The attorneys get to kind of lay the framework of what they're doing. They can object to every single question. Objection to form. That's how you do it. You object to the form of the question because the form of the question either calls for hearsay, the form of the question might be leading, the form of the question might call for a legal conclusion. That's what you're objecting to. You object to the form of the question. The witness is then instructed to continue to answer the question because at the end of the day, you get a transcript. The transcript then goes before the judge, and you get to designate certain parts of that transcript that you want heard in court. And then the judge looks at any objections that are made on the record and says, I'm going to rule on this objection. I think the objection was proper, and this part should be excluded. Why am I making this point? I'm making this point because in a deposition, you have to view the deposition as though it is actual trial, and you have to object to every single question contemporaneously at the time the question is being asked in order to preserve that objection should they wish to play that video at trial. This is important here because Mr. Hughes, what he just does there is he reads a portion of the medical record and he reads it out loud and he says, quote, "This was the observation. Do you see that?" That's the only question. That's not a question asking for the doctor's knowledge. That's a question that's kind of just regurgitating the medical record itself and trying to give it additional emphasis because you're having someone testify to it. That question is objectionable because it's leading. And also, as we've seen in this trial, the judge doesn't allow people to simply read off of a document to refresh their recollection. Then you're not allowed to basically just read the document itself and say, oh, yeah, that's what it says. That's an objectionable question. But in a deposition, these types of questions are oftentimes asked in this format because you're trying to navigate the witness through a great deal of information. You're trying to get the information that's in their head, out of their head, and onto a transcript so that you can use it later. My suspicion is that in this particular deposition, and with the way that Mr. Hughes conducts his depositions, there were not a lot of objections after questions of this type because it kind of sounded like the attorney was just reorienting the witness and navigating them to a portion of the page. But what Mr. Hughes is doing is actually reading into the record certain portions of these medical records. 90% of this doctor's comments, 90% of her testimony was saying, generally speaking, yes. And the doctor was being asked to opine and give her impressions of notes by other physicians. You can see the problem there. That's speculating. It's hearsay. It is any number of objections. But if an objection is not made at the time of the deposition, you can't exclude it later. I brought that up because I didn't really think that this added too much other than just to bolster the medical records that were already in the file. So I wanted to make that point because I thought that was interesting when I was listening to this. I was saying, what's this doctor adding? What is she adding from her own personal knowledge and experience? It wasn't a whole lot. It was a lot of just regurgitating a lot of what we heard in the medical records, a lot of what we read in the medical records, and then asking that doctor to opine on third-party observations that are reflected in the notes. So it went a little far for my mind on this one. And I think that had the objection been made at the time of the deposition, some of these questions might have been stricken. They wouldn't have been allowed. But because the objection wasn't made at the time the deposition was taken, these are allowed to come in. How much harm does this do to the plaintiff's case? Not a whole lot. The records are already in evidence. The jury can review the records. They're allowed to. Now, they're not going to be able to review, what is it, like 10,000 pages of medical records while they're deliberating. I hope they don't. That's a lot of records. But that's essentially what's happening. People are asking, isn't that hearsay? Yes, it is. Isn't it speculation? Yes, it is. But in the deposition, the attorney has to object contemporaneously with the question. You have to preserve the objection. If you don't preserve it, it's waived. So a judge viewing a transcript like this, and you want to make the objection later, the judge says, well, you waived it when it was being asked. That's the proper ruling. It might feel odd, but it's up to the attorneys to assert those objections when the question is being asked and when the information is being elicited. That was my observation with this particular witness. There wasn't a whole lot more than that was added to that particular mix. Let me see if there was any questions on this particular topic. I do want to bring this up. Canonical Heat, the mods are magnificent. Hug them and hit the like and subscribe. Canonical Heat 1, thank you for reminding me to ask people to hit the like button and subscribe. We are navigating towards, let me see here. I think I had it pulled up at some point in time. Because there's a live count ticker. It's kind of fun to look at. I haven't been on YouTube very long, but you can see we're approaching 200,000. With this trial and the trial coverage, there's a lot of people interested, so perhaps we can get that number over 200,000 and maybe do a celebration stream at the end of that. So that's one comment. Please remember to like the video. It does drive people to the channel and drive people to actually view the content that I feel is pretty significant. And then 2, you can subscribe. If you subscribe, free to you, no charge at all, and you get notification of additional videos that are being published and additional times that I go live. So that was that. Second point that I wanted to raise here was the mods. I usually do live streams once per week on Fridays. Like I said, I'm a full-time practicing attorney. I usually do lives once per week. My mods are usually tasked with managing a chat that is somewhere between 2,000 and 3,000 people one time per week, one evening per week. This particular trial has asked triple, quadruple, quintuple duty of them, and they have been doing a phenomenal job at moderating the chat and making sure that we maintain focus and that we're being respectful of the parties involved. So please thank the mods. Thank you, mods, for all that you do. You have been incredible throughout all of this. It has made life so much better, and it has made the streaming of these recaps possible. I could not have done it, and I could not do it without all of you. So thank you. Thank you for that. So let's keep going with our testimony. But before then, I think we have to swoop. We have to swoop to our next bit of testimony, right? Yeah, let's do old swoop. It's a cat riding a unicorn. It's a cat riding a unicorn. That's what it is. And where was I in this bit of testimony? Come on, Rob, where were you? 156.26. 156.26. Here we go. Go ahead and make sure I have the header pulled up, because the person we're hearing from next is Dr. Elliot Krane. This is the defense's heavy hitter. This is their expert. Yesterday, we had some dialogue about what the defense's case was. You know, the question of whether Maya had CRPS. And from what I had heard, even from the defense's witnesses, that there was kind of an acknowledgement that there was a past diagnosis of CRPS. And Mr. Hunter gets up yesterday as he's previewing their argument and says, no, we absolutely refute the diagnosis of CRPS. And in my head, I'm going, well, your witnesses haven't really done that. I was going, well, yesterday there were people that kind of testified to CRPS being questionable or questioned, but no one's really come out and said, no, she didn't have it. Well, I was wrong, because Dr. Krane, he had me looking at him go, wow, okay, that's where we're going with it. That is where we're going with it. So let's hear from Dr. Krane himself.
This way.
Please, Lord. Good morning.
Good morning.
Would you tell us your name, please, sir?
Elliot Krane.
And what is your occupation, Dr. Crane?
I'm a physician.
And where do you presently practice your profession?
Actually, I retired on May 1st, but prior to that, Stanford University at in the School of Medicine.
Okay. And you retired, when was it, May 1st?
May the 1st.
Okay. And tell us, if you would, please, sir, where you received your background or your education and training to become a physician.
I went to medical school at the University of Arizona in Tucson, Arizona, graduating in 1977. And from there, I did a pediatric residency at the Massachusetts General Hospital in Boston. Following that, an anesthesiology residency at the same hospital, and then a fellowship in pediatric anesthesia and critical care medicine at Boston Children's Hospital. And that was all finishing at the end of 1983.
Are those programs at Massachusetts General and Boston Children's affiliated with Harvard?
Yes, they are.
And did you become board certified?
Yes, I did.
And did you tell the jury what specialties you became board certified in?
First in pediatrics, and then anesthesiology. Both of those were in 1985. And then in subsequent years in, well, also not long after that, in pediatric critical care medicine, intensive care medicine. And then after that, in pediatric anesthesiology, once that specialty board was established, which wasn't for a few years, and also pain medicine.
And what have you focused your practice on over the last few decades?
Initially, it was in 1984, it was a combination of pediatric anesthesiology and pediatric critical care medicine. And it wasn't long after that, about 1985, my interest began to shift to pediatric pain management. And that grew as pediatric critical care shrunk. And then it's been largely pediatric pain medicine for the last 20, 25 years.
Okay. And where have you had occasion?
20 to 25 years. 20 to 25 years in pediatric pain medicine and pain management. So the experience is there. The experience is definitely there.
To practice your profession?
After my fellowship training, the first place that I went to work was at the University of Washington, practicing. That was my academic appointment, practicing at the Seattle Children's Hospital. And then about 11 years later, I was recruited to go down to Stanford University, which had a new children's hospital, to be the chief of pediatric anesthesiology and to establish a pediatric anesthesiology group there.
And did you do that?
I did.
Okay. And did there come a point at which you established a pediatric pain clinic at Stanford University?
Yeah, we set up the pain clinic not long after I arrived at Stanford in 1994. And it was a small clinic to begin with, and it grew rapidly over time.
Okay. Tell us what the focus and scope of the pain clinic at Stanford has been over the past 20 some odd years, 30 some odd years.
Well, at the beginning, it was a day a week, and then it was 2 days a week and 3 days a week, and it wasn't long before it was 5 days a week. Now we're seeing maybe 11,000 appointments a year. So it's become quite busy. It's a multidisciplinary clinic. So we have on staff pediatric pain medicine specialists. Right now there's 7 of them, and pediatric psychologists, also 7. We have pediatric psychology postdoctoral students, 4 or 5 of those, physical therapists, and then we also work with occupational therapists and child psychiatry.
And as of 2000, let's say 2016 and 2017, what was your role at that point?
At that point, let's see, that was 7, 8 years ago, right? So at that point, I was I'm just trying to. Yeah, so at that point, I had pretty much stopped doing pediatric anesthesiology. It was limited to maybe 2 days a month. And not long after that, I stopped altogether. And the rest of my practice was devoted entirely to pain medicine for children.
And it did at that time, and since you've been involved in it, as the pediatric pain clinic at Stanford dealt with pediatric chronic regional pain syndrome?
Complex regional pain syndrome, yes.
I'm sorry, mispronunciated. To to what extent have you been involved in the treatment, in the diagnosis, evaluation, and treatment of pediatric complex regional pain syndrome?
To what extent? Well, we see probably at the present maybe 100 new cases a year, about 2 a week, I would say, some weeks more. And we work together as a team, so it isn't as if one physician kind of owns a patient.
All right. So his background and credentials. Dude's credentialed. He's credentialed. He is a multifaceted expert. He can testify to various things, but particularly he is brought on to refute a lot of the claims of CRPS as a diagnosis. So let's fast forward to some of where he gets into his review of these records.
Well, Dr. Cantu,
Yes.
are there other records that you've reviewed regarding the case?
Yes, there are some blog entries by Maya's mother, and some emails from Maya's
So
mother.
he reviewed the
to
blog
herself.
entries.
And let's see what else. Some photographs of Maya at different times of her life.
Okay. All right. Let me backtrack a bit if I can and just ask you some general questions regarding complex regional pain syndrome and some of the other syndromes that bring us together today.
Yeah.
Tell the jury, if you would, what chronic regional pain syndrome is from the standpoint of someone who treats that condition in your specialty.
Complex regional pain syndrome.
I'm sorry, what did I say?
Chronic.
I'm sorry, complex regional pain syndrome.
A lot of people do that because it is a chronic regional pain syndrome. So complex regional pain syndrome means what the words say. It's complex, it's complicated. The cause of it is not known. There's several hypotheses, but over the last decades, we still haven't nailed down exactly what the primary cause is. There's probably a genetic vulnerability that leads to it. It's regional in that it affects a region of the body. Typically, in children.
I'm going to let his testimony run for a little bit. And this is a good point. I didn't bring this up earlier. The judge ruled on the emails early in the day. I wanted to get to his testimony because I want to just recap that. The judge ruled the emails in. The emails are in, not because of what we were discussing about the relevance, et cetera, one way or the other. They're in because they were Beata's emails and they're viewed as a party admission against their interest. They are contemporaneous writing of the then existing state that Maya was in. The judge viewed that to be an admission against the interest of Maya because it's also contextual in that how Maya's experience was back during the ketamine coma, that lays foundation to how a treating physician might approach it. So it gives context to the jury of the then existing mental and physical state of Maya when she was in that ketamine coma, so that the jury understands that when Maya was presenting at the hospital, she had this past experience which could have been manifest in her. You could have seen part of that past experience. And that would aid in the doctor's assessment of whether and how to treat Maya. So the emails are in, but the judge has not really ruled on the issue of how far we're going into mom's Munchausen's by proxy. And this doctor avoids a lot of it. So I think that Hunter is kind of dancing that issue still for the moment. But yeah, so we're going to listen to about 8 minutes of his testimony. Because, well, we're going to do that and we're going to go to his cross. Spinny wheel, stop. Stop,
Delayed.
spinny wheel.
Typically in adults, it's an arm, which is mainly a factor of what kids are doing versus what adults are doing. Kids are running around soccer fields and football fields and baseball fields and have leg injuries, very commonly twisted ankles, for example. Whereas adults don't do that, but they'll oftentimes trip and fall and break their fall with an outstretched arm, and that will start it off. It usually follows a rather trivial injury, like a sprain. It can obviously follow a more significant injury, like a broken bone. Sometimes it follows surgery. It affects initially one limb of the body that has had the sprain or the operation or the fall or what have you. And it begins at some point after that injury occurs. I have a colleague who's an orthopedic surgeon who gets CRPS repetitively. He's an outdoor runner. He's a trail runner. So he's frequently stepping in gopher holes or snake holes and twisting his ankle. And what he tells me is that all right, I'll skip past that. So at some point in time, it can be days or a week or two after the injury occurs, the pain shifts from the pain of the injury, a twisted ankle or what have you, to what we call neuropathic pain, which is pain that has its origins in the nervous system. Oftentimes by that point in time, the original injury is healing. And the pain is very different than the kind of throbbing deep pain of a broken bone or a twisted ankle. The pain moves to the surface of the limb, the skin, which has a burning quality. It becomes exquisitely sensitive to touch. Even the lightest touch, such as pulling a garment of clothes over that skin, is so excruciating the child can't do it. They can't sleep with bed sheets over their affected leg. They sleep with their leg either dangling off the bed or on top of the bed sheets. And then there's physical findings associated with it as well as the symptoms the child's reporting. Very specific physical findings. This goes on for a length of time until treatment begins.
And what, in your experience, is well, first of all, you've described for us how many cases, or an estimate of how many cases the pain clinic at Stanford has seen in the pediatric setting. How frequently does this disease occur in pediatric patients?
Well, most pediatricians will never see a case in their entire career. So it's that infrequent. Consequently, most pediatricians aren't even aware of it or don't know what to do with it. Typically, somebody comes in with this exquisite limb pain and they'll send the child to an orthopedic surgeon. And most orthopedic surgeons are aware of this problem because it occurs in their practice. And then they'll send the patient on to a pain clinic. Sometimes it's seen by a physical medicine or rehabilitation specialist, sometimes a neurologist. So the frequency is not really known. It's probably on the order of 1 in 100,000 children that get this. But as I said, it's so infrequent that most pediatricians aren't aware of it and will never see it in their lifetime.
How is it that your clinic sees that many patients if it occurs that infrequently?
Well, there's something like 50 million people or 45 million people in the state of California. We're the only multidisciplinary pain clinic in the state of California, the fullest service pain clinic. So we get referrals from all over the state, as well as from neighboring states, Washington, Oregon, Arizona, Utah, Nevada, and as far away as the East Coast. We've had patients come to us from Virginia, Boston, Pennsylvania, and we've had patients come to us internationally from various countries in South America, Australia, New Zealand, England, for example. We get patients from all over because of the reputation that we have.
And to what extent, well, within the universe of pediatric complex regional pain patients, how many present with so-called whole body CRPS?
None. Nobody does.
And why is that?
Because, as I said, it starts in a limb. It's a regional pain syndrome. It can, in some cases, spread, and it does spread, but not right away, not early in the disease. Usually it's after months or actually more like years. It can affect the opposite limb. It can spread proximally. It can affect an arm. So it can spread, but it typically spreads to other limbs. It doesn't spread to other parts of the body. I can't say why that is, but that's certainly the case.
What is the recognized treatment in your experience for pediatric complex regional pain syndrome?
The most important, the foundation of treatment, the kind of treatment without which it will not get better, is physical therapy.
So this is where he begins his assessment. So the foundational treatment is physical therapy, occupational therapy, and there's some form of psychotherapy that you have to engage in. But this doctor, he's their expert. He is an expert in CRPS. He's an expert in CRPS. He's completely an expert in CRPS. I have no basis to dispute that. This dude's been practicing medicine for longer than I've been alive, and practicing in this field for longer than I've been alive. So this is where he starts to give his opinions on how CRPS should be treated, which is relevant on the medical malpractice side, because the question is, if the diagnosis is CRPS, how do we treat it? What is the standard of care for treatment? The doctor's outlining what the standard of care is, and he's outlining it. And the reason the defense calls him is because he outlines the standard of care that is substantially similar to what the hospital is saying that they did. So this is why this witness needs to be there. The defense needs to call him. And I get into this. This is why we call these cases the battle of the experts, because it's about who you believe, who's more credible, who holds weight in your eyes of the authoritative figure on how we treat CRPS from the medical malpractice standpoint. Now we get into more of it, but I'm going to let him go for a little bit more because he's going to talk about the standard of care. And we're going to go into a little bit more, not just standard of care, but the ketamine, because he has opinions here. And some of this gets brought up on cross, and I do want to, I'm going to go to that in a moment, but I do want to give him the chance to say it in direct, because from the hospital's perspective, this is their best witness. And if I'm on the jury and I hear this witness, the information that you're gaining from this particular witness, he's an expert, is in such stark contrast to what I heard from the plaintiff's position that now I'm weighing, well, maybe the hospital is reasonable. And based on his assessment of what the standard of care is and how the hospital should have gone about treatment for this, that a lot of the things that the hospital did was in conformity with that. So I'm going, okay, from the malpractice standpoint, maybe the hospital's okay. There's questions he doesn't answer, though, that get brought up on cross.
Therapy and occupational therapy. Occupational therapy is a little bit different than physical therapy, even though the child doesn't have an occupation, it's still what it's called. But a combination of physical therapy, occupational therapy, and psychotherapy by a qualified psychologist. Those are the fundamental things that will make it better. Everything else, we do other things, of course, but everything else that we do for CRPS, complex regional pain syndrome, is only useful in as much as it supports physical therapy and occupational therapy. So, for example, if the child cannot tolerate physical therapy because their limb is so painful, we might add medications to reduce the pain. We can't eliminate the pain, but we can reduce the pain. We might do a nerve block to put that limb to sleep. which is effective for a limited period of time. You can't block the nerve for weeks or months, but we can for days to get the kids started in physical therapy. So the other things that we might do are only useful in as much as they facilitate the practice of physical therapy, without which we can't make patients better.
Is there a role for ketamine in the treatment of pediatric chronic complex regional pain syndrome?
We do use ketamine at Stanford. There's a number of places around the country, a small number of places around the country, that use low dose ketamine in children. There are still many, if not most, children's hospitals, if they have a pain service, restrict the use of ketamine to the intensive care unit environment in any dose. We have a more liberal hospital, and we were able to convince them that using low dose ketamine outside the intensive care unit is safe. And it's something that we reserve for refractory cases that we cannot make better after a full court press, which would be intensive physical therapy every day for weeks, typically 10 or 12 weeks, psychotherapy every day for the same period of time, and using all the drugs that we have on the shelf that are to.
Did you hear what he said? So what he was relaying there was we go to that ketamine therapy after we have tried what he called the full court press. Physical therapy, occupational therapy, psychotherapy every day. These are the things for weeks. He's saying for weeks on end. That's when they go to it. Now, the plaintiffs have presented evidence that they had tried that and that they went to ketamine after that. So this is, yes, Susan, I see your comment. We can agree. Experts are allowed to have competing opinions. It doesn't mean one of them's a liar. I didn't say that. I think he's credible. I think he has an opinion just like Dr. Chopra did. Guys, I want you to remember, Dr. Chopra had an opinion about the quality of care and what should have been done. It was contrasting this, but two experts are allowed to have different opinions. So I think this witness presented from a credibility standpoint, from an expertise standpoint, he's an expert. He had my attention.
Some degree effective in CRPS. If those things don't work, we will then put the child in the hospital for a 5 to 7 day ketamine infusion. But as I said, it's a low dose ketamine infusion in contrast to what was used in Maya.
While we're on that subject, can you define for the jury a low dose as opposed to a higher dose?
Our ceiling maximum dose is a milligram per kilogram per hour, which we've only used in one patient over the last decades. Typically, we start at about 0.1 milligram per kilogram per hour, and we increase the dose every 6 or 8 hours by 0.1 milligram per kilogram per hour until we reach a dose which is effective in reducing pain, or a dose at which unacceptable side effects occur, or a dose at which sedation occurs. And then that becomes our ceiling. So typically, our dose is going to be in the range of 0.3 to 0.6 milligrams per kilogram per hour, except for that one patient in whom we had to go to 1.
Compass Point administrator. I can't make comments about what's happening in the chat. I'm telling you that I think this expert has credibility. I have questions, just like I had questions with Dr. Chopra and any of the other individuals. I have already made the comment. I don't want people assessing him as a person. You can assess his credibility. You can do that. But we're not going to attack the person. And I don't know that I've seen a lot of people attacking the person. People are allowed to have conflicting opinions. A lot of people have made their opinions very well known, that they believe the hospital was in substantial conformity with a lot of the things that were being said. And to some extent, I kind of agree with some of the things that were being done. Attempting to wean Maya off of ketamine, the ketamine being a surprising dose, that was shocking, that there was things that they wanted to do to question the diagnosis. I think these are all things that are completely appropriate. I think that we get to additional questions when we start talking about what the hospital did as far as investigation. So I do want to remind people, please be respectful in your comments. Please. It's a sensitive topic. A lot of people are on both sides of this issue. One of the problems that I have had, Dr. K, I'm sorry. It was a bad pause. Hang on. There you go. Better pause. Better pause, Dr. K. I didn't mean to do you dirty like that. One of the things that I have tried to remind people over and over and over and over again in this particular case is that we have medical professionals that are testifying on the stand. And medical professionals, by and large, these nurses, practitioners, doctors, physicians, they see us at our worst. A lot like lawyers, they see us at our worst. The things that they see on a daily basis, the abuse they take from patients, parents of patients, outside providers, lawyers, everybody is unlike anything that a lot of us have to deal with on a daily basis. I try to afford them all a significant amount of grace and respect because I have not been in their shoes. I have not walked their shoes. So please try to keep that in mind when you're making comments about the evidence that we're hearing presented.
Heard the term anesthetic dose of ketamine. What is that?
And ketamine, you have to realize, is a drug that has conventionally been used as a general anesthetic. You can put somebody to sleep and operate on them with ketamine. The dose that is necessary is a starting dose of about 1 to 2 milligrams per kilogram given intravenously. So that would be about 27 milligrams to 50 milligrams in somebody the size that Maya was back then. In an adult, it would be 70, 100, 150 maybe milligrams. And then about 3 milligrams per kilo per hour will keep them asleep in order to do an operation. So you can take somebody's appendix out at 3 milligrams per kilogram per hour.
Okay. Now, how does that compare with the dosages that were used in this case by Drs. Kirkpatrick and Hannah?
Objection.
So we approach.
It's ramped up to
Ketamine use.
2.5 milligrams per kilogram per hour. I don't remember what Hannah's starting dose was, but it was substantially higher, and went up even higher and higher still, so that by October of 2016, he was using doses in the range of 25 to 30 milligrams per kilogram per hour, 10 times the typical anesthetic dose for a patient.
Okay. Going back, well, let me ask you to focus on the period of time between September 23rd, 2015, when the patient first saw Dr. Patrick, and the time that she came to All Children's Hospital. Can you describe the course of her therapy and disease during that year?
Yeah, the course that she demonstrated was one of perpetual reports of severe, intolerable pain, weakness, inability to use her limbs, inability to bring her ankle back to a neutral, normal position where the foot is about 90 degrees to the foreleg, and behavior that was often described as a screaming type of behavior, which was attributed by her mother, and her doctors to severe pain, and that there was an undulating course, and that there were episodes in which, or time periods in which her pain seemed to be less, and then severe pain again, and then less, and then severe pain. But overall, if you look at the entire landscape from September of 2015 or summer of 2015 until the fall of 2016, you have to say that she was no better, in fact, getting a lot worse.
Was there any difference in function as far as the patient was concerned during those 2 dates, as far as you could determine?
When her function was much worse by the time October 2016 came around and she was admitted to All Children's Hospital, she said that she could not move her limbs. She could not lift them against gravity off a bed. She had significant pain, so that she would be screaming in pain, would not tolerate anybody touching her. Her mother would not allow anybody to touch her because of the pain that would occur.
Going back, if we could, to the point of Dr. Kirkpatrick's initial involvement in September of 2015 and the therapy that he offered. Do you have an opinion that you can state within a reasonable degree of medical probability whether the treatment he offered was within the standard of care for the treatment of pediatric complex regional pain syndrome in this country?
It was not within the standard of care.
And why is that?
As I said earlier, ketamine is reserved in our institution nationwide for patients whose pain is refractory and unresponsive to the fundamental treatment, which is, as I said and will repeat, intensive physical therapy, advancing to intensive physical therapy if necessary, occupational therapy, psychotherapy, drug management as an outpatient, oral drug management. His first treatment was ketamine. So it was, at the very least, it was very, very premature. In addition, the way that he administered ketamine, which was in significant doses, was a violation of the standard of care in terms of his record keeping. There are specific not recommendations or guidelines, there are specific ways that records need to be kept during an anesthetic type infusion as he administered to Maya. Remember that going up to 2.5 milligrams per kilogram is virtually a general anesthetic. His record keeping was just terrible. It was skeletal, minimal at best in terms of measuring vital signs and recording level of consciousness.
We will get to record keeping at cross-examination. We will get there.
That is to say, it violated the standard of care for an anesthesiologist.
Was there any harm to Maya Kowalski as a result of this?
There was no harm to Maya in terms of specifically receiving the ketamine. Fortunately, she didn't have any complications from it. And not surprisingly, her pain reports were diminished after ketamine, because ketamine is not only just a great analgesic, it also has psychiatric effects, which you may be aware of. You may know that ketamine is being used more and more frequently by psychiatrists to treat depression and anxiety, which isn't to say that that's what she had, but only to say that there are emotional/psychiatric effects of ketamine. So in that sense, she was no worse. But I would say the harm that was done was that instead of being referred to a center that knows how to take care of pediatric CRPS, he went ahead and administered ketamine. And then when that really didn't work, it didn't provide sustained benefit, he referred her to Mexico. And that's another story that you'll probably get into, I suppose, with your questioning. But I think the important damage that was done was in denying Maya effective therapy for CRPS, and we're assuming this is what she had at that time, because if she had CRPS and if she had effective therapy for it at her age, I would have expected her to improve and recover in a matter of weeks. And
So this was the part of his testimony that I was going, oh, are we going there? Is that where we're going? I was curious up until this point. And listening to it, I get it. Now, there's a lot of things that he contradicts about himself and his own observations that are his own testimony. If you played the whole thing through, you could find conflicting things that he says favorable for the hospital, that were things that were actually done by the plaintiffs. Now, I do want to point out make a point here. Dr. Krane, oh my gosh, Dr. Krane, I'm sorry. Hang on.
that wasn't done.
I'm sorry for the pause game. I'm sorry. Apologize. There were things that he said should have been done, and he just glosses over the fact that they actually were done. There are things that he says that his opinion is kind of glossed. You can tell where his opinion is going. He's allowed to reach it. He's allowed to have skepticism. That's fine. But he opens himself up to attack on some of the contradictory statements he makes. And an important caveat here is that Dr. Krane never met with Maya, never met with her, never spoke with her, never did anything beyond reviewing medical records. Now, you guys might remember the Goldwater rule from the Johnny Depp case. The Goldwater rule, and I had this question going up, and I had to take an aside and do a review of whether any of this was not just like feeling wrong, but was actually impermissible from a standard of care standpoint. The Goldwater rule talks about psychiatric or psychological opinions, that if you have not met with a patient, you cannot speak and opine about their psychological diagnosis. You can't give a diagnosis. You guys might remember this from Dr. Spiegel from the Depp case. This doctor walks that line really finely. He's very clear to say that Maya does not have CRPS. He suggests there might be other contributing factors to the conditions with which she presents. But from my recollection of his testimony, he doesn't opine as to a psychological condition. And if he does, I can accept being wrong here. But I think he walked that line pretty carefully in saying no CRPS, which you're allowed to do based on the medical records. It's a medical diagnosis. It's just like if someone appears for a broken leg, right? You can have an expert testify to the scans, to the doctor's notes, to things to say whether the patient had or did not have a broken leg. You're allowed to do that without meeting with the patient. This dances that line pretty carefully, and I wonder if any of the jurors felt uncomfortable about this, because the reference to not meeting with Maya was something that I felt uncomfortable with.
Okay. And that's something I hadn't asked you before I go to Dr. Cantu. Was there an adequate trial of alternative therapy before ketamine was given?
There was not.
And if there had been, if you compare what might have been, so to speak, if the program pursued was similar to your clinic, what is the outcome that is expected or anticipated for a child such as this receiving standard of care therapy?
Maya, I think, was about 10 years old at the time. And I would say that 10-year-old girls, and I say girls because it's about 7 or 8 times more common in females than in males. Almost all of our patients are females with CRPS. We don't know why that is, but 10-year-old girls with CRPS are our favorite population to take care of with CRPS. Why? Because they're the easiest to take care of, they recover the fastest, and they don't recur. Of all the kids we've taken care of, we've never had a recurrence of CRPS in a child whom we've treated at the age of 10 or 11 or 12. As kids get older, it becomes more difficult to treat, more challenging. And as children advance through adolescence, their teen years into their young adult years, it begins more and more to take on the pattern of adult CRPS, which is a much more difficult condition to treat.
Let's talk about Dr. Cantu's treatment. Can you describe for the jury your perception of what it consisted of?
His was called ketamine coma. It was coma in the sense that a patient on the kind of doses that Cantu uses is going to be unresponsive, unconscious. In other words, under general anesthesia. So it's not really coma, but he's getting general anesthetic doses. So the patient is under general anesthesia for the 5 days of this infusion, which starts at 3 milligrams per kilogram per hour and advances day by day to a higher dose. I think the highest dose that Maya received was 5 milligrams per kilogram per hour, maybe 6. those doses result in complete general anesthesia or coma, which I don't think is a correct term to use in that instance. For that reason, Dr. Cantu has to treat the patient as if they're under a general anesthetic, which is what we do in the operating room, except that he's doing it in an intensive care unit, which is a good environment for that. Patient is intubated, that is, they have a breathing tube placed into their mouth, down their windpipe. It's attached to a mechanical ventilator to breathe for the patient because they won't breathe adequately on their own. They have to place a tube in the stomach, either to decompress it or to provide nutrition, which was done in Maya's case. So they are basically under a prolonged general anesthetic for 5 days.
Is there, is that treatment, in your experience and based on your background and training, within the standard of care for an anesthesiologist providing care for pediatric complex regional pain syndrome in the United States?
It is not. It is not within the standard of care, and that's why it's not done anywhere in the United States.
Let's move on. Did it appear to you, based on the review of the records that you saw and the depositions you reviewed, did it appear that the treatment rendered by Dr. Cantu in Mexico was successful in any sense of the word?
It wasn't successful in the sense that any benefit that she realized was not sustained over a significant period of time. So within 4 or 5 or 6 weeks, she was reporting an increase in pain. And that's in contrast to the patients that we have experience with and other places have experience with.
All right, we're going to revisit some of his direct in the cross, rather in the jury questions. But I want to get to the big ticket item that the defense needed to get out of this doctor. And it was right around here.
Doctor, have you seen records regarding this patient from after her discharge at All Children's Hospital?
I've seen Dr. Wassenauer, is that his name pronounced correctly? Her pediatrician. I've seen his records following her vision.
Do you have an impression of how she did following discharge from All Children?
Back up, what was your question just prior to that?
Overruled.
I'm sorry.
He's asked if I'd seen records from Hannah, from Maya after her discharge.
Yes, yes, yes.
Yeah, I saw Wassenauer's records. And it seemed like she was doing exceptionally well.
Did it appear to you that she had recovered function in that period of time after discharge?
Yes, she was in high school, she was in athletics, was doing quite well.
Recognizing that your frame of reference may not extend all the way to the present day and that you've never examined this patient, do you have any opinion that you can express within reasonable medical probability?
Those are 2 important caveats. I thought those were 2 important caveats.
Regarding what future needs she may have?
Well, I don't think she had CRPS to begin with, so I won't comment on if she did have CRPS, what her future needs would be. But I would say, from what I know, I don't see that she would have any particular needs at all, except for support from a mental health professional.
That's all I have. Thank you.
That was his last question and the last answer. I found him credible. He talked about the criteria for assessing and diagnosing, right? I'm not a doctor, folks. I don't know these things. He talked about the criteria for assessing and diagnosing. He talked about the different things that she presented with that were inconsistent with those criterion. He dismissed a lot of he very emphatically said these are not lesions or scratches. He said there was no discoloration. He said that the temperature difference wasn't significant, but again, he's reviewing the records. So I found the information that he provided. This is one opinion. This is an opinion among many. That's where we are. We have an opinion that is an opinion by this doctor who's a remarkable professional who does this job. It's one opinion among several. So that's where the jury is right now. They have one opinion among several opinions. So we go to lunch. We have a break at lunch. And then after lunch is when we return. Then where are we for? 3:10:46. 3:10:46. That was where we left off. Then we go to lunch and we're at 4:47:52. 4:47:52. Jury's back.
Dr. Krane, how much have you been paid
Cross-examination.
so far for your testimony?
I don't have a running total in my mind, I'm sorry.
Well, is it over $100,000?
No.
Is it over $50,000?
No.
How much do you get paid per hour for testifying in court?
$750
An hour,
an hour,
including prep time,
including prep time.
including travel time?
No.
What's that?
$300 an hour.
Okay. Would it be safe to say that you're between $25,000 and $50,000 being paid now or in the future for your testimony?
Not to date.
Okay, two things. One, Doc, I'm going
Less
to
than
get
that
better
today.
pause. There you go. Better pause. Two things. One, I started this comment, Creed M. It surprised me how cheap he was. You'd think he'd be at least 100,000. I thought so too. This was inexpensive. Now, one of the things that I did notice was that he fell into the trap that a lot of experts do, which if you listen to Anderson's question, and it's phrased this way intentionally because it's suggestive in how the question is phrased. How much have you been paid for your testimony? The appropriate answer that you're supposed to give is, counsel, I've been paid for my time here today. I'm not being paid for my testimony, for the substance of my testimony. The fact that he didn't really navigate that might leave in the minds of the jurors the impression that he's a hired gun. That's what the question is aimed at doing. It's a standard question. It's always the first question asked of any expert. Always. You'll hear it from the plaintiff side, defense side. It's always, how much are you being paid for your testimony? And they phrase it that way because they want to leave the impression with the jury with that this person is being paid to testify for their testimony. Dr. Crane's being paid for his time. That's the appropriate answer. Okay. But he kind of slips into this one. I don't view that negatively because I'm an attorney. I don't know if the jurors view it that way or not. But again, I'm an attorney. I get what the question's asking. Jurors might view it differently. But yes, the fact that he's being paid, or he has been paid, less than the $50,000 at this point with his review of this file, that's kind of significant. So I did note that as being rather significant. Opinions are Drew's alone. Shocked how quickly the chat's already dismissed the doctor. I haven't. I'm listening. I've listened all the way. Catching up on this one real quick. Darkle Luge G. Hey, Law and Lumber, can you please spread the word? A friend is battling Merkel cell carcinoma. She's currently having a fundraiser to get specialists in to help. It's Merkel cell carcinoma fundraiser by Mindy Sapphire Moria on GoFundMe. So Darkle, I will make the comment that I have trouble with this kind of stuff that I can't vet independently. If people want to go and take a look at it, please do. Please do. I oftentimes will say, please go look at that, but please make sure that the cause that you're contributing to is verified or is valid. Do that independently, please. Because I just don't want to send people down the road of saying, please contribute to this. I'm not endorsing it one way or the other. I will say, anyone struggling with this, the contributions are probably very much appreciated. So if there are people that want to check this out on GoFundMe, please do that. Mindy Sapphire Moria, MindySaffire Morea on GoFundMe. It's a Merkel cell carcinoma fundraiser. So I wanted to pull that up because thank you for the very generous super chat. And then Jennifer Lynn, thank you. General question: is it normal for one attorney, Anderson, to handle almost all the witnesses direct and cross? Nope. Especially in a trial this long. No. Why isn't Whitney doing more? I gave my opinion on this earlier in the trial, and it was essentially that if you want to bestow in the minds of the jury the notion that it is Maya and her legal team, which is smaller than the hospital and the bureaucracy of the hospital, then one way to convey that is by having a single attorney get up after the hospital has cycled through attorneys. I think that was their intention. I think it was intentional. I think that now, you see Mr. Whitney give a cross-examination later, and I'm going to pull up Paula Dees' testimony because she's my other witness I want to talk about tonight. Mr. Whitney does a great job in cross. He does a great job. But I think that the day in, day out is starting to wear on Mr. Anderson. So you're going to see more of Mr. Whitney. And I think it's a good move. Mr. Whitney has a remarkable cross of Paula Dees, but I think that was to convey a visual more than anything else. But no, it is not normal that one attorney handles all of these things. Okay. Okay. Ryden, as a patient, I've had and currently have the worst doctors. I've also been saved by doctors. And as an advocate, I've been on both sides. Okay, Ryden, as an attorney, I've been on both sides. I 100% get this. Vast majority of people in medicine do it because they care. We should treat them accordingly, flaws or not. I agree 1000%. Thank you. So let's go on to Mr. Anderson's cross-examination because he makes a couple of points really quickly that I think were important for him to make.
I don't know how much it will be after this week.
Uh-huh. Okay. And so how long did you spend total with counsel in the, say, month prior to your testimony?
2 hours last night, and there have been some phone calls over the last month.
Well,
Maybe about 3 or 4 hours of phone calls.
before your report was issued, though, you spent considerable amounts of time with counsel, did you not?
Before the report was issued, which report? I don't know what you mean, Mr. Anderson.
You had done a report in this case back in 2021, I believe.
Oh, that, yes.
You did, right?
Yeah, I don't know what you mean by considerable amount of time.
Over 10 hours.
I provided you my billing records today, and I don't remember the details of them, but you have them in front of you, I think.
Okay. Is gastroparesis a symptom of CRPS?
No.
Best of your knowledge. Okay. All right. So you had testified first. Let's talk about Dr. Hanna. You had testified that you felt that Dr. Hanna's treatments did not work, right?
Correct.
And that was because, and one of the reasons for all the weaning was because the dosage just kept going up and up and up. Is that right?
Yes, that's
Okay.
correct.
Oh, and incidentally, there's nothing wrong with being paid by the hour, is there?
No, of course not.
No. That's $750 an hour. Just checking on something. All right. So
That should have been
you said it
objected
been going
to.
up
That's
and
what
up
we
and
knew.
up, and that's as to the dosages. Now, is that individual dosages?
I'm not sure what you mean by that.
Well, the per infusion dosage.
The total over 4 hours has gone up, and the hourly rate of infusion has gone up.
Okay. So how many infusions, what was the infusion rate in June?
Can I look at my notes? I can tell you if I look at
Sure.
my notes. Okay, they're in my briefcase. May I get them?
Sure. Sure. We got the progress note if that helps you.
There's going to be a monitor here, sir.
Okay.
Know whether she has testified under oath here that these treatments were the only
Wait,
thing.
hang on. Sorry. Fast forward too much. Because I went to get the notes. It took a minute. Give me 1 sec. We'll be right back. Spinning wheel, stop. Come on, spinning wheel.
Infusions were going up through the course of spring and summer.
I was incorrect. Yes, I misremembered the infusions going up in dose. They were stable at 1,000 until September 29th.
Okay. Well, you've known about this case for at least 3.5 years, have you not?
Yes, I have.
Have you ever actually spoken to Maya Kowalski?
Of course, I know.
And have you ever examined her?
No, I haven't.
So you don't know whether she has testified under oath here that these treatments were the only thing that helped her.
Objection to
Do
asking
you?
my witness to comment on the testimony of another.
Would you repeat the question, please?
Are you aware, or are you not aware that Maya Kowalski has testified that the only thing that helped her pain were these infusions?
If she's testified to that, I'm sure that she did, but am I aware of it? No, I wasn't aware of that.
And doctor, isn't the ultimate goal here to help the patient,
The ultimate goal is to improve function and diminish pain.
which is helping the patient,
That's
right?
Yes, I wanted to be more specific than just using the word helping.
And the main thing that Maya Kowalski complained about was pain, was it not?
And loss of function.
All right. And so through the course of the spring and summer, as the dosages from Dr. Hanna were going on, did anybody ever show you any of the videos of how Maya Kowalski's function improved?
I only saw one video of her, and I don't remember the date, and that was of her dancing on her bed, but I don't recall when that figured into the chronology.
Did you see any of Maya and her brother in the pool?
No.
Did you see any of Maya on a walker on its side, using that as sort of a exercise bar?
No.
So if I'm understanding your testimony then, the thing that people did wrong here was that they did not follow your clinic's program.
No.
Is that right?
Absolutely.
Okay, but you felt that physical therapy, occupational therapy, CBT, cognitive behavioral therapy, these are the cornerstones, right?
Well, I didn't say CBT. That's just one form of cognitive. That's just one form of psychotherapy, and it's more complicated than just use one form. But I said that those were the cornerstones, the foundational treatment of CRPS, and that's something which is nationally, if not internationally, recognized.
Did you go through the records of Tampa General Hospital and see what she received over the course of 1 month inpatient during the summer of 2015?
Yes, I did.
And did she have physical therapy?
Yes, she did.
Did she have psychological therapy?
She had some. Yes.
Did she have occupational therapy?
Yes, she did.
And she had that for a month, right?
Correct. That's right.
And at the end, the physical therapist said she wasn't improving, right?
The PMR doctor, the rehabilitation doctor, felt that she was ready for discharge and to continue the same therapy as an outpatient. In other words, she no longer required inpatient hospital admission. And these things are generally done as outpatients.
Got it. Did you or did you not tell the jury on direct examination that under your approach, especially for a 10-year-old girl, when their mind is developing, that your program here could work in a matter of weeks?
I said in a matter of weeks, but not 4 weeks. And 4 weeks is never enough.
So now it's more than 4 weeks you need.
I said weeks, and generally our program lasts for 6 to 12, sometimes more. But I would say 10 weeks is about the average for CRPS.
For the people that were there actually seeing Maya Kowalski as she left Tampa General Hospital, she had not improved after 4 weeks of the therapy that you advised would work. True?
Let me just check my notes out, please. Well, I'll answer your question in the following way. She wasn't performing significantly better at physical therapy, but she was doing things when she wasn't.
I'll answer your question the following way. Mr. Anderson, redirect him. I'll answer your question the following way. No, Dr. Krane, I asked you a specific question that calls for a specific answer. When you imply that you're going to say, I'll answer your question the following way, it's suggesting that you're not really hearing my question. So let me rephrase the question to you. Regain the reins. Please regain the reins. If Mr. Anderson has a flaw, it's that he does not tighten the reins when the witness goes astray. Mr. Shapiro does the same thing with the plaintiff's witnesses, but
Aware of being observed, or when her mother wasn't in her presence, that indicated that in fact there were physical improvements in her behavior and in her appearance.
You got that from Bonnie Rice, correct?
No, I did not. I'm pulling that from the Tampa General Hospital records.
Was Maya out of the wheelchair coming out of Tampa General Hospital?
No, she was not.
Was Maya Kowalski still complaining of severe pain?
Yes, she was. I'm sure.
Doesn't CRPS, one of the problems with diagnosing and treating this disease is the variability of some of the symptoms?
I wouldn't consider that a problem. It's certainly a fact of the disease that different children have different magnitudes of symptoms
At different times, correct?
It's not a smooth course to recovery. It's more of a sawtooth course to recovery. But
Right.
yes, the general trend is in one direction.
Good days and bad days.
I wouldn't quite put it that way, but I think I wouldn't quibble with you if that's how you want to describe that.
And are you aware that Maya Kowalski had a relapse in September of 2016?
We are, predicating this whole discussion, Mr. Anderson, on the assumption that this is CRPS, which was not the belief of the Tampa General Hospital staff or the Lowry Children's Hospital staff. And so it wouldn't necessarily be expected that her course is going to follow the typical course of CRPS if she didn't have CRPS.
Doctor, I just asked you whether or not she had a relapse in September of 2016.
I think you said a relapse in CRPS, and that's why
Yes.
I'm saying, well, I don't think she had CRPS, so she could have had a relapse of CRPS. But yes, she had a decrement, a decrease in her behavior, function.
I get what he's trying to say. Bad pause
Yes.
game. Bad pause
And
game.
are you
times
aware-
three.
that
Stop.
through-
Blinking. I get what he's trying to say. This to me, if I'm in the jury box, I kind of don't like how he's answering. I get why he's doing it, right? He doesn't want to concede the CRPS diagnosis. He can't do that. He's the expert for the hospital. But this is where, to me, he starts really kind of waffling. He starts waffling. And where he starts saying, well, I'm not gonna concede the hypothetical because you're saying that she had CRPS. And then we get into more of this. And Anderson, this is where Anderson hits his stride and starts hitting some points.
Through the entire course of the spring and summer of 2016, she was on that sawtooth path of getting better.
She would respond to ketamine, and then after, typically, her ketamine seemed to be at intervals of approximately once a month. And so she would feel better after the ketamine, and then she would begin to feel worse, and she would ask for another ketamine treatment, and she would feel better again. So yes, it was an undulating course. She felt better after many of the ketamine infusions. That effect wore off, and then she went back for more.
Well, this is a disease that you don't cure, you manage, correct?
What disease are we talking about?
Complex regional pain syndrome.
Again, I don't think she had complex regional pain syndrome. So if you want me to answer hypothetically about CRPS,
Hypothetically then, CRPS, you manage that, you don't cure it.
no, I would not put it in those terms.
Well, you think you can give somebody a shot and it'll go away?
No, of course not.
Or a pill?
Of course not.
So you think that just by continuous physical therapy, what the rest of their lives, that's going to do it?
I haven't said that either.
Okay, so I understand that you say that you do not agree she had CRPS, but you've been through the records, have you not?
Yes, sir.
All right, and so you have seen then that
Here's where Anderson starts scoring points. I mentioned that the doctor testified that it was inconsistent to some of the records that he reviewed himself. And I think the doctor was remarkably credible on direct. I think that he was the strongest witness by far for the hospital so far. But this is where you get to point out some of the inconsistencies. So now Anderson gets the opportunity to kind of point some of these things out. And he does a good job.
for instance, Dr. Chopra noticed or documented. Okay. First, I want to know now, you are reviewing the diagnosis of CRPS by at least 5 physicians. Are you not?
I'm telling
There
you
you
that in my reading of the chart and in agreement with many physicians who saw her in children's hospitals, that I didn't see any evidence to support the diagnosis of CRPS.
Well, none of them after Dr. Kirkpatrick disagreed with the diagnosis. True?
After Dr. Kirkpatrick,
Once Dr.
our
Kirkpatrick,
children's hospital did not agree with the diagnosis.
well, are you aware that they billed for it the entire time?
It's a different matter. Once something gets in the medical record, it often stays there, and the billing.
Ooh. Point Anderson. This point. For me, it's less about what they did. I've made my position on the matter pretty clear here. When it comes to weaning off of the medicines, when it comes to questioning the diagnosis, when it comes to the things the hospital is doing, cognitive behavioral therapy, physical therapy, occupational therapy, I don't have a problem with the treatment that they went through. That's not where I have to, that's not where I am having an issue with this case. Factually, just trying to align the facts to the law. I'm not having a problem with that. So if a child presents with a prior diagnosis of CRPS, the hospital is, if they are beginning treatment there and the treatment's not working, they're right to question the diagnosis. They are, and they can engage in a certain amount of testing to question that diagnosis and figure out how they can reorient their treatment. I'm there. That's where I am. Like, the hospital has a good defense there in that if she presents with CRPS, but the facts don't align, we can reassess and try to reorient treatment. But going down the road of the hospital didn't think she was diagnosed with CRPS. And if that's what you're going with, if that's what you want to say, no CRPS. She never had it. Carried over from the records. If that's what you're going with, that question from Anderson and that response from Dr. Krane kind of kills it for me. It just kind of does. They billed for it. And the doctor's explanation, well, that's just a billing department. That's a billing department. well, you know what? I'd be pissed to get that medical bill. I mean, think about that for a second. If, for example, the hospital ran up $1 million in costs treating you with expensive chemotherapies and various treatments for cancer. And then it turns out that they said, oh, no, you never had cancer in the first place. And Aetna, whatever it's Aetna, Blue Cross, Blue Shield, whatever your insurance provider comes back to you and says, oh, here's your portion of this. It's $300,000. And you say, well, they said I didn't have cancer. Well, all the records say they did. They submitted under this code. They diagnosed you. They submitted with diagnosis. This is the part that if I am a person on this jury, the second I hear that question and someone says no CRPS, I am going, what? What? And if this is the explanation that you get out of that question, I have a problem with that. Yeah, they have a medical malpractice. Yes, they have a fraudulent billing claim. They have a fraudulent billing claim. They do. But it's not just, this is a party adopted admission. When an individual submits a record or consents to a record or receives benefit from a record, and that record has contained in it a statement, CRPS diagnosis, that can be viewed as an adopted admission against their interest. It's an exception to the hearsay rule. So, I found that troubling. That was tough for me. I don't need an expert on the topic either. The jury is, they're not experts on the topic. They get to hear this and they get to have opinions on this.
People simply look at diagnoses that are written early on and carry through.
And all of the doctors and nurses and social workers through the entire 3-month stay, they just let it follow through, the diagnosis.
I don't know. What you mean, they follow through.
All right, and so, for instance, Dr. Barr, a neurologist, diagnosed it independently as CRPS, true?
No, not true.
Dr. Spiegel diagnosed it. Are you disagreeing with whether he's a neurologist or not?
No, I'm telling you that he didn't diagnose CRPS.
Are you saying that Dr. Elliott did not say he refuted the diagnosis?
No, Dr. Elliott said it was not CRPS.
I could have sworn he said he did believe it was CRPS yesterday.
I wasn't here yesterday. I didn't hear what he said.
All right.
But
Dr.
in his
Spiegel,
deposition, he said it was not. And in his notes, he said,
did Dr. Spiegel testify it was CRPS?
remind me who Dr. Spiegel is, please.
Did Dr. Hanna testify it was CRPS?
Yes, Dr. Hanna. I didn't hear his testimony in court because
Dr.
his deposition-
Kirkpatrick.
Dr. Kirkpatrick called it CRPS.
Dr. Cantu.
Dr. Cantu.
And so you agree with the Budapest criteria, I gather?
Yes.
All right. And so in going through, you had to notice that, or see, I'm sure counsel provided you with photos showing dystonia of Maya.
Well, I think what we know in hindsight is that it wasn't dystonia. It would come and go at will. And there were lots of times when the dystonia was not there. And within the same day that it was there, or it seemed to be there. So it was something which was, it wasn't dystonia. It was, could have been conversion disorder. It could have been confabulation. But dystonia is something which is there all the time and then gradually gets better. If it does get better and then goes away, it doesn't come and go. The stiffness in the ankles doesn't come and go on the same day. And there were many descriptions at Tampa General, at Lowry Children's Hospital, and at All Children's Hospital of her feet being in a normal posture under the covers or during the day, and then not in a normal posture when she saw that she was being observed.
Move straight to the doctor's testimony, the portion regarding.
No, it's
psychological
in.
diagnosis.
It's in. You
So
let
now,
him.
is Maya's dystonia voluntary or involuntary?
Can't say.
How
You
do you
agree
know
it's
that?
involuntary? In
No,
other
I
words,
said I
she has no
can't say it
control.
was voluntary or involuntary. I don't have enough knowledge of her psychological state to make that observation.
When somebody is under general anesthesia, they lose the ability to control their arms and legs, do they not?
That's true.
Can we bring up 2529-61?
All right, we're going to go to jury questions. So we're going to go to jury questions because we've covered a lot of the subject matter and I want to get to what the jury asks. We're not going to go to the debate over what questions do get asked, but we're going to go to 608-33. And instead of a swoop, we have our own little intro to jury questions. So we're gonna bring the jury. We're gonna bring this jury. We're gonna bring this jury and the jury questions.
The court has said our favorite thing: bring the jury, bring the jury, bring the jury.
Okay, so the jury box you guys saw. Jury questions. We're not gonna listen to all of them, but we are gonna listen
Please
to
be
some of the
seated, members of the
explanation.
jury. I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that all correct? You have not been approached by anyone about this case. Is that correct? And you have seen lots of media accounts about this, correct? Okay. I will tell you, we are able to ask most, but not all of the questions, but for the vast majority of the questions, we are going to be able to ask.
Pages.
And Doctor, you understand you're still under oath?
Yes, sir.
18 pages.
Let's start. Let's try to write the time down. Doctor, how is Maya doing after her discharge from Johns Hopkins Children's Hospital?
The latest information I have is that she's doing very, very well. Looking at her physical therapy notes after discharge from January, I think the last note I looked at was in July. She's gone in January from being wheelchair bound, unable to bear weight, all of her weight on her feet, having to stand with support, get out of a wheelchair and transfer to a bed or a toilet with support and help. That was how she was in January. She underwent physical therapy roughly twice a week, going forward from there. And by July, she's described as walking around, no pain complaints. There was a quotation from her father in one of, I think, in the summertime, just describing how well she was doing. And I understand that today she's a high school student. She's doing well. She's in some kind of athletics. So as far as I know, she's doing quite well.
What are withdrawal symptoms of someone that is physically dependent on ketamine?
Well, I've never seen or heard of anybody in my life getting doses of ketamine like this, 1,000, 1,200, 1,300 milligrams in just a few hours. So I can't say that I have any experience with that, but I have seen ketamine withdrawal. Back in the old days, when we had kids undergoing radiation therapy at Boston Children's.
This is a point I passed on a bit. The doctor did testify at length about how significant the amounts of ketamine that were being administered was and how that would be a concern to any treating physician, nurse, or anyone that's being presented with that case. I do not want to dismiss that, because if you walk into an ER or a hospital and you say, I am presently receiving this amount of ketamine, and I'm not talking about the experts. I'm not like the experts back then. That's not this. If you walk into a hospital and you say, I'm receiving this dosage of ketamine, based on what we have learned as far as the dosage is being given, all of the ER nurses, everyone there, their jaws would hit the floor going, how are you walking? Now, there's a lot of information and context that gets brought up here. She was getting a lot of ketamine. And yes, we have confusion about what ketamine does or doesn't do and what it's allowed to do and not do. But my gosh, man, from the hospital's perspective, if a mom presents with a child and mom says the child's receiving this much ketamine, I'm having alarm bells go off. I'm listening more, but the doctor testified a lot about the amount of ketamine that she was receiving.
Children's, they would come in every day, Monday through Friday, for 6 weeks for radiation therapy, and we would have to put them to sleep because you don't want them to move at all when there's radiation being going into their body. You want to kill the bad stuff, the cancer, not the good stuff. So we used to use ketamine. We have better drugs now, but we used to use ketamine. And as we saw with Maya, the dose would need to be increased from week to week to week because they develop tolerance. That means you need more of the same drug in higher doses to get the same effect. That's tolerance. The other side of that coin is when somebody develops tolerance, they become increasingly physically dependent on it. So if you have any drug, that's what happens. And the symptoms of withdrawal are going to be the opposite of the symptoms that you're trying to get by using the drug. So think about narcotics. Narcotics make pain go away. Narcotics.
Bad example, because narcotics they actually have an addictive principle to them, or they are addictive in their very nature. Abusable. We talked about this. When a drug or a medication is abusable, meaning that the relief you receive from the medication can create a psychological dependence on that medication. You feel like you need it. And when you come off of that, when you don't do it, you want that relief that much more. So a little bit different. Now, I don't dispute the fact that someone that gets taken off of that level of ketamine when they have been titrated to that amount being therapeutic, right? When they wean them off of that, I don't dispute that there are, if not just withdrawal symptoms, there is an element of psychological withdrawal where you are no longer getting that level of relief, and your brain is going, I need this, I need this, I need this. And that it's a difficult thing to explain. So I don't know that doctors, and every doctor that has done it, I don't know that any one of them has really done it in one sitting at a level or articulated such that we would understand how we have come to understand this from the various doctors who have testified. So the fact that a drug is abusable, which means the relief you gain from that drug can create a psychological dependence on that drug, because you are experiencing that relief, and when that relief is no longer there, you want that relief back. So that's something I think that's kind of interesting. But I quibbled with him on this response, but he doesn't really answer the question.
Constipation, narcotics cause drowsiness. The opposite of those three things that happen with withdrawal. They feel pain all over their body. Their bones feel like they're breaking. They have wicked diarrhea, and they're wired, absolutely wired. They're not sedated. They're the opposite wired.
Is he from Boston at all? Is there anything? He just said wicked diarrhea. Like he said wicked diarrhea. The guy said wicked. The guy said wicked in testimony. He had wicked diarrhea. One, I've never heard of that concept of wicked diarrhea, but I can see how diarrhea can be wicked. Squirrel. Sorry, that was a squirrel. Squirrel thought. K-Rab, thank you for the exceedingly generous super chat. Thank you. Very kind of you. $100 super chat. Billing is a huge issue. I went to the ER with excruciating abdomen pain. Did a CT scan, nothing found. I asked about the appendix. Doctor said, no, CT is gold standard. Doctor sent me home. CT report said could not image appendix. Doctor called at 8 a.m. and said, come immediately. It was appendicitis. PD times 2. Yep. I have a similar observation when my father had cancer. When they had cleared him originally when they had said we don't see any resurgence of the cancer. And the doctors were saying the next place it would show up might be the brain, might be the chest, right? My initial thought, and I asked the doctor, well, why don't we do a CT scan? Why don't we just check? We're here now. Why don't we check? No, you don't need to do that. We're clear from cancer. Where did it show up? The brain. I know people who have reported very, very similar instances where, you push for an examination or a test. And I know that the medical system is very heavily burdened, but I really do wish that we were less focused on the insurance reimbursement issue, rather whether the hospital can get reimbursement for a certain piece of care and what care that patient feels might comfort them. For example, a CT scan. If they're asking for it, what's the harm in it? And if the patient's going to pay for it. Thank you for the generous super chat, K-Rab. I'm sorry about that experience. This is an important case because it highlights a lot of things about medical profession and medical industry. I'm going to say medical industry. I'm not going to say the profession. I'm going to say the industry itself, that needs some fixing. So not the profession. The profession does a great job. These professionals are great. I'm tired of the industry creating a lot of red tape and a lot of red tape and a lot of bureaucracy for them to navigate. I believe that people enter the medical profession with the absolute intention of doing good for their patients. The bureaucracy is a whole lot of problems that I have. So
The same thing's true with every drug, you name it, every single drug. And in fact, in Maya's case, she was treated with steroids for her asthma in high doses. And when those were stopped, she had none of her own steroids in her body and had symptoms that could be attributed to having inadequate steroids and being at risk for infection and things of that sort. So with ketamine, when we used to give ketamine, we would see kids sometimes come in on Monday begging for ketamine. They had it Monday through Friday. They go home for the weekend. They're not getting radiation therapy. They come in at 8 o'clock in the morning for the radiation therapy. They can't wait to get their next dose of ketamine. They're anxious, sometimes begging for the ketamine. They feel pain because it's all the opposite of what ketamine does. So there's no question that ketamine, call it, is addictive, is habit forming, but physical dependence does occur with ketamine. And those would be the symptoms that I would predict. Fortunately, I've seen it rarely, and I've never seen a kid withdraw after such high doses because I've never heard of such high doses being given before.
Is it possible that the quote symptoms, end quote, Maya would present as quote CRPS, end quote, be withdrawal symptoms?
It's a great question. That was one of my hypotheses, especially when she was in the ICU at All Children's Hospital. She was agitated. She was screaming for ketamine. Those could have been withdrawal symptoms that she was having. And
that's the jury that's with the hospital.
What is the half-life of ketamine?
Off the top of my head, I'd have to look it up. I would hazard to guess it's in the range of, sort of like in the range of what morphine is, which would be 2 or 3 hours.
We have heard testimony that not all physicians that assess Maya, they did not always assess temperature changes or no color changes or assess her skin or other things, the Budapest criteria, or the other things on the Budapest criteria. Can you make a certain determination that it is not CRPS since you did not assess Maya during this time yourself?
Oof. Dr. Kirkpatrick and Dr. Hannah described her limbs as being cool. I don't know what that means. When I have a child with CRPS, one limb is colder than the other, and we use 2 degrees as the threshold. It's rather arbitrary of whether that's significant or not. Now, how do we assess that? It hurts too much to touch their leg with the back of your hand to see if it feels warm or cold. And Maya certainly wouldn't have let somebody do that by description. So what I use is one of those thermometers where, well, they're very common. They didn't used to be common, but you see during the COVID pandemic, you saw people shooting those at your forehead and measuring your temperature. A little laser beam comes out, which shows you where you're aiming at, and it uses infrared to tell you the temperature. So we use one of those. We buy them on Amazon for about $15, so we don't have to pay a medical supply company $100 for them, but they're the same device. So, and they measure temperature very accurately up to 1/10 of a degree. And so we have a chart. We shoot the big toe, top of the foot, the ankle, the shin, the back of the calf, the thigh, and we just record those measurements and compare left and right and look for a difference. And as far as color change goes, that's obvious. As I said, I provided some photographs to Mr. Hunter. He asked me for some photographs of what CRPS looked like in my patients. Some of them are really horrendous. You have one leg that's pink, one leg that's deep blue. So that's pretty clear. I didn't get that I don't know how Dr. Kirkpatrick and Dr. Hannah assessed temperature or anybody else subsequent to that, but I suspect that really wasn't done.
Doctor, you stated many times that Maya does not have CRPS, but also stated you never examined her. How can you come to this conclusion?
I can come to that, well, because I've seen 1,000 or 2,000 cases of CRPS, and it's sort of like looking at that scratch on her forehead. You look at that and say, "What's a scratch? It's probably a fingernail scratch." You know, you just
Bad answer. That's a bad answer. It's a bad answer. That was an opportunity for him to go through the medical records he reviewed, not just if it looks like it, if it smells like it, we see it. That's what it is.
know it when you see it. When you don't see what you're expecting to see with CRPS, it's not CRPS. I mean, if you told me somebody was an amputee and I looked at a picture of them and they had all four of their arms and legs, I would say, no, they're not an amputee. It's as obvious as that. It didn't look like CRPS. It didn't sound like CRPS by description. There were some emails that her mother wrote to herself, but in Maya's voice, similar to the blog that she was putting out. I don't know if that's something you were shown, but in Maya's voice, she's saying she's the youngest patient ever in the world to have total body CRPS. And then she said she's the youngest kid in the world to ever get ketamine coma. Well, I don't think she had CRPS. I don't think she had whole body CRPS. What are the odds that this child was the first kid in the world to ever have this? That's how I would say she didn't have CRPS. I don't think the odds are very large that she was the first kid in the world to ever have a condition that nobody else had ever seen before.
Is there any medical oversight on the dosing of ketamine?
I'm not sure what's meant by medical oversight, except this, that, for example, our hospital specifies an acceptable dosage range for using ketamine outside of an intensive care unit. You want to use more, you have to be in the intensive care unit, which is impossible. Why is it impossible? For the reason of ketamine, because insurance won't authorize it. The ICU is super busy and there's just not a bed for something like that. So I'm on a email list server of pediatric pain. People, thousands of people from all over the world on that list server. And the question comes up from time to time. Somebody says, hey, we want to start using IV ketamine infusions in our hospital. And they ask for advice. And different physicians write in and give the guidelines that are in their hospital. I would say at Stanford, for sure, we have the most liberal guidelines of any children's hospital I know of. And we only allow it to go up to 1 milligram per kilogram per hour. And as I said earlier, in 20 years, we've only had one kid who needed to go that high. And she was a redhead, and redheads are notorious for needing higher levels of anesthetics than people who don't have red hair.
Is that a real thing? Hold up. Sorry for the pause game, Doc. Hang on.
There's a chemical reason for that.
Nope.
So,
yeah, that's a good pause game. Hold up. Is that a real thing? I know that people say redheads are fiery, but does it really take more anesthetic to calm them down? Seriously? This is real? I'm learning this now? Like, you actually have to administer more meds to a redhead? Whoa. Okay. All right. So like when like other people, like you just give them like a little bit of like a sleep pill, like they go down, but a redhead, you need a trank gun? Is that what the doctor's saying? Wow. Wow. I'm seeing so much in the chat. They anesthetize faster, they burn through it quicker. Wow. So many people. I am learning things today. My word. All right. Okay. That was something I didn't know that I learned today. Hey, I guess the redhead and fiery redhead, I guess, is a thing now. I guess it's a real thing. Now we have medical proof. We have medical proof that redheads require more anesthesia than the normal person because they're that fiery. So we have learned something new. We have learned something new. Inconceivable. I do not think that word means what you think it means. Wow. Okay. All right. So redheads and trank guns. Redheads and trank guns. That's what we need. Redheads and trank guns. That is what we learned today. Oh, there's a lot of redheads in the chat right now. A lot of redheads in the chat. And they are making their opinions known. So come on, Doc. Come back to us. We need you.
That's the medical oversight. Is there are policies and procedures that hospitals have that say this is what you can do, and outside these guardrails you can't do it. Now, who enforces that? If I were to write an order for 5 milligrams per kilogram per hour of ketamine in the hospital, the nurse would say, no, I'm not going to do that. And I might get into an argument with her or him, and they would pull out the policy off the web and say, it says right here, you can't go there. And that's it. I would be in serious trouble if I really did that.
Is it common for a diagnosis of CRPS to be questioned by physicians?
I think there was a question Mr. Anderson asked, I think Dr. Elliott, about honoring a diagnosis that comes in the hospital. How could you not honor Dr. Hannah's or Dr. Kirkpatrick's diagnosis? And to that, I would say, we don't honor diagnoses. We honor patients, we honor parents, we honor people. But a diagnosis is an idea, and they're wrong sometimes. You wouldn't want a doctor who accepts you from another doctor outside the hospital and just automatically agrees that this is the diagnosis, these are the drugs you should give. It's going to be your
Good
reputation
answer.
on the line
That's a good answer.
if that's wrong, because you're the one giving the drug. So you're going to ask the question, is this right? And sometimes it's just really obvious. You have, like in Maya's case, comes into the hospital with a diagnosis of CRPS, pain specialist is called and says, this doesn't look like CRPS. It just doesn't. And so then you have to take a step back and say, well, it doesn't look like CRPS. What else could account for what we're seeing? And that would be true for any disease. If somebody comes in with a cough and the doc on the outside says, I'm sending this guy in for pneumonia, I want you to treat him with antibiotics. And you put a stethoscope on his chest and say, he doesn't have pneumonia. You do a chest x-ray, he doesn't have pneumonia. You treat him for something else, what he does have.
Next question. Does the diagnosis of CRPS automatically raise questions of psychiatric issues?
No, never.
Next question. Do you require IQ tests to treat CRPS or for entry to your pain clinic?
Oh no, why would we do that?
Hang on. Ryan Man YYC, we love our redheads. We love our redheads. It's a bad joke. It's a bad joke about the ginger thing, but we all love our redheads. We know that was made in jest.
What role would IQ play in pain treatment, assessing meds or source?
It would not figure it out. We treat children who are cognitively impaired. We treat children who are near genius and everything in between. And we would treat them no differently, except that when you're treating a cognitively impaired patient, it's challenging to figure out what's going on because they can't really describe it, or an infant for that matter. But no, we don't do IQ testing. We don't treat anybody differently, whether they're smart or stupid.
If in a quote breakthrough case, end quote, it was whole body CRPS, would someone?
Did he just say whether they're smart or stupid? In response to the IQ question, I know you're tired, Doc.
Experience pain from a charm bracelet, anklet, pulling hair back tight, or application of mascara and makeup?
Yes, they would. Our children and women, adult women with CRPS, don't shave their leg with CRPS because it hurts so much to drag a razor over it. It hurts to drag a sock over it. They can't wear jeans. Our patients with CRPS, and probably all patients with CRPS in Florida, if it's in their legs, wear shorts 365 days a year because it's too painful to put pants on. Fortunately, I live in a place where that's okay.
Cool. Thank you, Feral Dragon.
You live in Boston. I think they're out of luck. But that's how painful it is. Yeah, it would hurt.
Has any pediatric CRPS case reoccurred in your center?
Yes, it has.
At what age?
It's never reoccurred so far, knock on wood, in children who started at Maya's age, 10 or 11. As I said, those are our favorite to take care of because they get better the
I want you to keep in mind,
fastest. And
this is his remark. This is his remark. Okay. So this is a key point here in the jury question. Now we're getting the jury questions. So it's about 5 more minutes on this, but now we're in the jury questions where he starts making the plaintiff's case. He makes the comment of an individual or a child, a minor child that happens to be female, which is the higher incident rate in CRPS. When he says that a child at Maya's age who presents with CRPS, when they are treated appropriately, the eventual relapse, there might be a relapse, but it could be years down the road. So the hospital has made a big part of their case focused around Maya and how she presents now. This testimony, if I'm the plaintiff, I am highlighting this. I am saying that the defense's own expert testified about how when we see children that present with this, they will oftentimes, if you treat it appropriately at this stage, if you treat it appropriately, then you might never see it for years and years and years to come. he starts making the plaintiff's case here. So this part was really fascinating to me because Doc, you are not saying what I think you're saying. Spinny wheel, I swear I am going to do terrible things to you, you spinny wheel of pause. You spinny wheel of pause, you need to get up to speed because I know what's going to happen. If I hit forward or backwards, you're going to do more spinny wheel.
And, they're usually cute little girls and you feel really good about restoring them back to 100%.
Oh God!
The teenagers tend to recur with greater frequency. And we published a paper on CRPS recurrences by sending surveys out to every patient we treated since 1984 and 1994, which is when I went to Stanford. And we sent it out. We got about a 35% response rate, which is pretty good for a survey, especially because we were using addresses and email addresses that were 20 years old. So we didn't know. A lot of the surveys came back as undeliverable. And what we found, we were kind of surprised that that ongoing pain was much more common than we thought it was going to be. About a third of the patients said they had no recurrence at all, no pain. And the rest of the patients had some kind of pain. Fortunately, most of them were mild. There's a young woman who's now a medical student who took care of a long time ago, 15 years ago. And she's an avid hiker. And she tells me when she goes on a really long hike, her foot hurts afterwards for a couple of days. And that's probably the CRPS. But so the pain can be persistent or recurrent, but it's usually not disabling. And then we have had children whose CRPS has roared back at 100%. They come back, they look sometimes even worse than they did in the first place. It could be a year, 2, 3, 4 years later. Then we do the same thing that we always do, and we make it go away again.
What was the length between occurrences of symptoms?
The length between
the occurrence of symptoms, and it goes back to the question about reoccurrence in your center.
I'm not sure I quite understand the question. Are you asking about the evolution of the development of CRPS after an inciting injury? It's usually days, maybe a week, 2 weeks at the most, but usually the change morphs from normal pain, if you want to call it that, to this really excruciating pain. We've had kids, a typical scenario, this is really typical scenario, is a child injures their ankle or foot in a sport, and they go to the emergency room, photograph, x-rays taken, and the doctor's probably not used to looking at pediatric x-rays. They look different than adult x-rays, and they can look a little funny sometimes. He says, well, I'm not sure if it's a fracture, so let's put you in plaster just to be safe. And they put them in plaster, and about 5 days later, they're in excruciating pain, and cut the cast off, and they have CRPS. Because immobilization is I think one of the triggers of CRPS, when you immobilize a limb. In fact, there was a study done by a colleague of mine named Stephen Butler in Sweden.
Sir, let me just, the question I had to do was between the length, so.
Did I answer the question? Typically, a few days to 2 weeks between an inciting event, if there is one, and the development of CRPS. In terms of recurrences, they can occur almost any time, but what I've seen is, I would say, 6 months to a couple of years for a recurrence.
Was it ever, or when has 25 milligrams per kilogram per hour been within the reasonable standard of care or used in practical application?
This part.
Never, not even for general anesthetic. Never. I've never heard of doses of that sort.
In CRPS, final requirement to rule out other diagnoses versus psychiatric requirement to find the same before diagnosis. Are these directives in conflict here?
They were in conflict with what Dr. Hannah and Dr. Kirkpatrick did. They didn't, neither of them read the notes from any of the hospitals where she had previously been taken care of. And I think if they had read those notes, they would have stopped and questioned the diagnosis. I hope they would have stopped and questioned the diagnosis, because I think those notes are very telling. They're, that the symptoms that Maya was exhibiting came and went. And her reports of symptoms and what the medical professionals observed, and by medical professionals, I'm talking about doctors, therapists, nurses, what they observed and wrote in the chart were very, very different, oftentimes, almost every day, than what was being reported to them by Maya or her mother. So that kind of discrepancy to me raises red flags. The child can go from, let's say, feeding herself with both hands, brushing her hair, smiling, to screaming in pain, and when a nurse comes in to give her a pill, say she can't lift her arms off the bed to put the pill in her mouth. There's something wrong there, and it raises red flags. I can't say exactly what it was. There's a few possibilities, but that isn't how CRPS works, and that should raise questions about the diagnosis.
Testimony has described Maya's Johns Hopkins All Children's Hospital visit as an, quote, interruption, end quote, in treatment. What was the presumed conclusion of the dosage for ketamine?
The presumed conclusion for the dosage of ketamine that she was getting from Hannah was it was too high by tenfold. The dose that they started in the intensive care unit was 3 milligrams per kilogram per hour, and that wasn't adequate to stop her from screaming in pain and thrashing. It was raised to 5 milligrams per kilogram per hour, and nobody felt comfortable going above that. So nobody had ever experienced giving doses higher than that in or out of an operating room. So that's where they leveled that off. Now, if you look at Whether the ACH admission was an interruption in her therapy, I would say it was, and that's a good thing. Because if you look at the overall trajectory, from when she was admitted to, let's say, the next summer, she was better, the number of drugs that she was on, starting with a huge list of drugs, and slowly narrowed down to virtually no pain medication at all by the next summer. She's on a little asthma medication, little allergy medication, but nothing directly for the CRPS. And yet, in spite of that, she's doing great in the summertime. And why was she doing great? I think because she wasn't going through periodic ketamine withdrawal, and she was getting physical therapy at Agility twice a week, almost twice a week, twice a week, almost every week for that entire period of time. And we're showing continuous improvement. A few other things could account for that improvement as well. She's growing up a little bit, etc. But the point is that what they did was they put a stop to what was being done by Hannah, and that was a good thing.
Now, Doctor, we're about halfway through the question, so let's see if
Okay,
we can just answer the specific question asked. There's going to be opportunities for others to ask follow-ups, so let's just try to answer that.
Okay.
The next question, can the CRPS pain starting in a limb radiate to other areas as well?
Yes, it spreads up to the body, can go all the way up to the thigh, even the lower back, and it can cross over to the other side in some patients.
Are most medical treatments for CRPS temporary, although effective for at least some relief?
Some patients are lucky enough to never experience CRPS again. And most patients, over 50%, that is to say.
Okay, to go to the next question, which I thought was really important. So next
children, over
40,
50% will have some
40.
recurrent.
Hang on. Because I want to get to other stuff we have to get to.
Change means lack of blood flow. That's why the leg turns blue. And if there's not blood flow, there's not warm blood getting down into the leg, so the leg's going to become cold. So they usually go hand in hand. The Budapest criteria, I think the question was, are they drastic or something like that? They're very, very useful. And they're not sacrosanct. They're not carved in stone. And sometimes children come in with very early CRPS, and they just haven't blossomed into the full picture. But you get the feeling that that's where they're going. And in fact, it tends to be where they go.
Next question. Is it your view that if a drug or, quote, way of treatment, end quote, that is approved by the U.S. government is the only valid or allowed treatment?
This
Truthfully,
part.
almost nothing we do is FDA approved in children. Almost nothing. So,
Surprise, surprise. Well,
no, I
doctor,
don't agree.
we have heard a lot of testimony about FDA approval and how that's a red flag. Typically, almost nothing that we do is FDA approved in children. My ears didn't just perk up, they went like a mile high. I was like, whoa, 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 whoa. Hold up, bud. Is that what you want to say? Like, that question was aimed at a different thing to allow you to explain something that you thought was a red flag in Dr. Cantu.
And they just haven't blossomed into the full picture. But you get the feeling that that's where they're going. And in fact, it tends to be where they go.
Next question. Is it your view that if a drug or, quote, way of treatment, end quote, that is approved by the U.S. government is the only valid or allowed treatment?
Truthfully, almost nothing we do is FDA approved in children. Almost nothing. So no, I don't agree with that. And almost every drug that we ever give kids has not been approved for the use in children by the Food and Drug Administration. So we're using them, it's called off-label.
Next question. I believe past witnesses' testimony used the term titration.
I mean,
And with many drugs, more maybe.
Really?
Sorry. I believe
That's
past
question.
witnesses'
That's your
testimony
answer.
used the term titration. And with many drugs, more may be needed to have the same benefit over time. Is ketamine similar to other medications?
That's different than titration. So there's two things in that question. One is titration and one is tolerance. So tolerance is when you're using the same drug over time and you need to up the dose to get the same benefit. That happens with opioids, for example. It happens with insulin for diabetics. One dose works and over time they get resistant to it, so you have to give them more and more and more over time. Titration is something that you do, let's say, over minutes or hours or maybe days. You start a drug and you don't get the effect you want, so then you up the dose. So we do that with Neurontin, gabapentin, for example. We start at 100 milligrams a day, but our target is about 1,800 milligrams a day in your average teenager. If you don't give them 1,800 milligrams right off the bat, because number one, they have horrible side effects. Number two, you don't know what dose between 100 and 1,800 is going to work for them. So you just slowly ramp it up. That's called titration until you get the effect that you want.
all right, that's where we're going to leave the good doctor. I know there's more, but we're going to leave the good doctor there. I saw this come in and I have to highlight it because it's remarkably generous. Orca 8995, $300 super chat. Thank you, Rob, for all you do while working a full day job. Orca 8995. The generosity is remarkably appreciated, and it's never necessary, but it's remarkably appreciated. This is a tough case to cover. It's a tough case to explain, and I am doing my very best. And I have a lot of faults. I have a lot of faults in the explanations that I give, in my ability to relay information in a completely neutral fashion, and I try to explain those as best I can. But my goal here is so that you guys understand the law. I'm trying to explain the law and how this case navigates itself through trial. Orca, that is remarkably generous of you. Thank you. Thank you. Thank you very, very much. Remarkably appreciated. And I'm getting word that the chat is asking for a sub count. Let me double check. Just double check before we go to our next witness. Where are we? So sub count, we are at 199,478. So we're close to 200,000. We're close to 200,000. Thank you guys. Honestly, thank you guys for all of the questions, commentary, engagement, interest, focus. Like I say, I'm just trying to break the law down. I'm trying to make sure that you guys understand what's going on in this particular case. It's tough. It's a tough case. It's a tough case, and there's a whole lot of grace we got to extend a lot of different directions. Let me see if I've got questions on this particular doctor before we go to our next doctor. Snazzy, if I was a juror, I would see him as a hired hand by J. Hatch to call the family and Maya liars. You can do that. Lindsay, what do you call a redheaded ninja? A jinja? That's funny. That's funny. Corey, I thought this doctor ended up being a good witness for the defense. Not sure about Dr. Dees, though. Dr. Dees is tough. Dr. Dees is tough. Go through this. Rob, did you feel like the witnesses contradicted themselves repeatedly when answering defense questions versus jury questions? Yes, I did. That was what I pointed out there. Thank you, Caitlin, for that. I was trying to point that out because we have a lot in there where the doctor's going through, well, we don't have any FDA-approved medication treatment for children. And going, well, you just said that this was outside of anything that was approved or understood. But then you're saying, I got what he was trying to say, but it was contradictory. Lynn 2574. We aren't glossing over him calling special needs kids stupid, are we? We treat smart or stupid. That bothered me a bit. JM, if you don't want comments about persons, why was a unicorn judge allowed? Well, that was at the early part of the trial, before people started making a lot of remarks that were personal. I love the judge. Love this judge, bright, fair, and down to earth. I do too. I think he's done a great job in ruling fairly on this case. Very fairly on this case. Gabby, if we find this doc to be credible, has he really neutralized the plaintiff's most damning allegations? That question remains. We'll get into that with Dr. Dees. Even on damages, much of Maya's claims relate to PTSD from Kathy et al., whether she had CRPS or not. That was what we discussed yesterday and the day prior. This case, to me, is becoming less and less about the CRPS and more about what's done by the hospital. And the more they focus on the diagnosis, the more that I'm focused on those instances of conduct. And I cannot imagine I'm the only person. Do this. Melody, Scott, Zindel, thank you. Interesting suggestion towards medical gaslighting death in this case. I have seen people send me this video. I have not watched it yet. I will try to watch it. Right now, I'm just trying to cover the case. And with the time that I have, while I'm doing the law work, and I have tomorrow, I have a continuing legal education seminar I have to go to and do law work and cover the recap. So couldn't post a link. It's because links are disabled because people link to things that aren't really appropriate in the chat. The video on the YouTube channel is Medical Secrets. So if you guys want to check that out, please go search Medical Secrets. Yellow pill. Wait, what was the context? All meds not FDA approved for use in pediatric patients, or specifically ketamine therapies not FDA approved for pediatrics. It was all. It was all. But he had previously said ketamine. So ketamine, in my opinion, falls within the category of all. And that was a question that I think opened him up to a little bit of skepticism from my part. So I had some trouble with that. I wanted to make a comment before we get to the next witness. And let me do this real quick. So I'm going to swoop so that we can acknowledge it, and I can highlight it as being a comment that's separate and apart from the testimony. Okay, so I had previously remarked about the jury in this particular case, and that was based on my general understanding of a majority of jurisdictions, which when they send a civil jury back, the civil jury is generally between 6 and 8 jurors. Okay. And that jury, generally speaking, has to vote by majority. In civil cases, usually in a lot of jurisdictions, it's majority. So people have asked me this question, and I gave the recount of what my general understanding was of civil trials, which is majority. I was texting with Peter Tragos from Lawyer You Know, who does remarkable work and also great channel to check out. He's a practicing lawyer in Florida who does medical malpractice and plaintiff's cases. And I was texting him, I was saying, so just clarify if I'm crazy here. It's 6 go back and it's majority, correct? And he goes, no, Florida is different. Florida civil juries are 6 that go back, and it has to be unanimous. So I want to clarify that because I didn't want this chat to be led astray. And I didn't want my remark to be the one that led them astray. So in Florida, from a Florida attorney, civil jury has to be unanimous. 6 individuals go back. And what Peter told me before, or also, was that for the most part, we were texting earlier today, for the most part, most jurisdictions, the attorneys know who the impaneled jury is, rather who the deliberating jury is. So who the actual designated deliberators are. So they know the 6 that are going back, and they know who the 6 alternates are from the very beginning. They know that. So based on what Peter is telling me, I'm getting the understanding that the plaintiff side and defense side know who the 6 that are designated to go back and deliberate are. They know that it has to be unanimous, and they know who the alternates in the box are. So I wanted to make that clarification because I was getting the question and I might have given incorrect information, and I wanted to correct that. So thank you, Peter, for clarifying that and for giving me that information. So I wanted to put that between swoops so that you guys saw it before we got to our next witness. Okay, back to the continuation of the recap. We have Dr. Paula Dees come up. People are going to have comments about Dr. Paula Dees. I will remind the chat that we're not going to comment about people's names or their appearance, because I was watching Law and Crime earlier and watching Tampa 13 earlier, and there was a lot of comments that were very childish and stupid. And I mean stupid as in, when I refer to stupid, I mean comments that are childish, ignorant, dumb, name calling based on the last name Dees. Those are going to be removed instantaneously by the mods. Don't do it. We're not going to comment about names. Be adults. Most of you are. Almost all of you are. I just relaying what I saw. It pissed me off when I saw it, when I was watching this trial coverage as it was. So I'm making that comment now just because it made me upset. So Dr. Paula Dees, let's hear what you got to say.
Mine's on the scene. There you go. Okay. Thank you. Your next witness, Mr. Hunter. Mr. Shapiro.
Yeah, would you like us to proceed forward, Your Honor?
I do, and in another half an hour to an hour, we'll take a break.
Sure. The defense calls Dr. Paula Dees.
There's enough about her testimony that you can make comments about. You don't need to go after the name.
Stand here, face forward, and raise your right hand.
Please solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do. Please do not see the scene.
May it please the court.
You may proceed.
Thank you, Your Honor. Good afternoon. If you could introduce yourself to the jury, please. And Dr. Dees, what is your profession?
I am a pediatric hospitalist at Johns Hopkins All Children's Hospital.
What is a pediatric hospitalist?
A hospitalist is a pediatrician that specializes in taking care of hospitalized children, so outside of the ICU, but on the general medical service.
So let's go back a little bit. If you don't mind. Where did you get your medical
My medical degree I obtained at Florida State College of Medicine.
degree? And what did you do after obtaining your medical degree?
I attended pediatric residency at the University of South Florida, training both at Tampa General Hospital and at All Children's Hospital. And then after graduating residency, I stayed on and was hired as an attending physician at Johns Hopkins All Children's Hospital, and I have been there for the entirety of my career since.
During your training or your residency, did you receive any awards or honors?
I did. I would have to refer to my CV for a complete list, but during medical school, I was inducted into the Alpha Omega Alpha Honor Society, which recognizes top academic performers in medical school. I was also inducted into the Gold Humanism Honor Society, both in medical school and residency. That honor society is a peer-nominated process identifying physicians that are felt to be kind of exemplary, empathetic, and compassionate physicians.
Are you board certified?
I am, both in pediatrics and have my subspecialty certification in pediatric hospital medicine.
And you may have said it, I apologize. How long have you been with All Children's Hospital?
I did complete my residency training and did training at All Children's. I have been an attending physician at Johns Hopkins All Children's since June of 2011. So just had my 12-year anniversary as an attending, but if you include the 3 years of residency training, I've been there for almost 15 years now.
And I think you touched on it earlier, but if you could explain to the jury, what does a hospitalist do?
So a hospitalist is a pediatrician that takes care of patients that require hospitalization. So their medical condition is severe enough to require hospitalization and not just be managed by their pediatrician as an outpatient or in the clinic setting. So if a patient comes in and needs to stay overnight for whatever condition, we will continue to evaluate them, monitor and treat them throughout the course of their hospitalization. We often work with other subspecialists and consultants. We have a multidisciplinary team at our disposal there at the hospital. We kind of think of ourselves as like a quarterback, so to speak. So we are typically in charge of the case in most scenarios, although we do consult on other cases. But we'll typically then put together a team of specialists, whether we also include things like physical therapy, speech therapy, et cetera, and kind of coordinate the care between all those subspecialists and serve as kind of the main attending physician for the care.
Did you have a chance to care for Maya Kowalski during her hospitalization at All Children's between October 7th, 2016 until she was discharged in January of 2017?
I did.
Okay. I'm going to walk you through a couple of your encounters and see if we can get an idea of what you provided care for. We're going to start with Joint Exhibit 100.
All right, we're going to fast forward a little bit because I want to get to the relevant part of her testimony. So, where was it? 7/21/58. So the big part of this is that she is Paula Dees. You'll remember references to her in prior testimony, but where we get relevant, in my opinion, here is where she's talking about the investigation, the hospital. Well, investigation or question the diagnosis and what they do in the course of questioning the diagnosis.
Small erythematous means red. So just a small red area. An induration means the soft tissues are kind of inflamed. So there is an area of red inflamed tissue over her port. So we are drawing attention to the fact that there could be a potential developing infection or complication associated with her port and that we were monitoring that very closely.
What happens if a port becomes infected?
If a port becomes infected, it can develop in a range of symptoms all the way up to a life-threatening infection such as sepsis, where the body becomes overwhelmed with infection and has struggles to compensate, and you can actually die from sepsis. So that is the range of anything from a superficial skin infection all the way to the potential for death.
I wanted to ask you about an order, which is at 1001-1079. It's the second one down where it says order for seizure monitoring unit.
Correct. I do.
Who is Dr. Amy Dalasania?
She was another one of our residents at the time.
Was this order?
AG, I'm aware that comment was to me from Della. I don't mean to scold the chat repetitively, but the mods right now are handling like triple the load that they're usually used to handling. And every now and then we get trolls that come in and make comments. So it's not a reminder to the regulars. I know the regulars, you guys have done amazing. A lot of you, most of you, 99% of you are amazing people. I just like giving warning to people. So.
Placed pursuant to your request.
Yes.
Okay. Well, why are you ordering seizure monitoring?
So we were trying to move Maya to a room that had a closed circuit video capability. So the name of those beds is our seizure monitoring unit. My concern.
This is the move to the EEG room. Okay. This is the move to the EEG room.
In learning Maya, meeting Maya, and evaluating her, and also learning of other reports from colleagues and consultants in the case, was that Maya had repeated discrepancies noted in what she said she could do and what she would be observed doing when she wasn't aware that she was being observed, so to speak. So for example, and we may get to it, but there was a time where we'll ask her, can you move your legs? And she would say no. But then later that same day, I would see her holding her legs up in such a way and crossing her feet to where someone that can't move their legs would not be able to do that. So as part of my diagnostic evaluation and trying to really go through and do my due diligence to see what I felt her true underlying diagnosis and disorder was, I wanted to be able to observe her in a way, because there was differences in her performance when someone was a medical provider was talking to her and asking her questions and asking her to perform, and what she was probably doing, whether it was consciously or subconsciously, I can't say.
She speaks fast. I'm going to back up and repeat that because it's kind of important. This part is very important. This is the justification for the move. And it's a lot of diagnostic, and she uses a lot of the right words. So when she's commenting about this, I am perking up because I have been looking at this as one of the issues outside of the CRPS diagnosis as one of my big concerns. Okay. So in this case, I think there are certain incidents that the hospital needs to explain. One, the EEG monitoring. That room, that 48 hours, they need to explain that. They need a good explanation. Two, Kathy Beatty's questions, or the Kathy Beatty's photographs. Three, Kathy Beatty's monitoring of the phone calls. Okay. This is the observation part. This is the observation part. And I'm going to go back to let's go 1.25 because she does talk fast. Let's start around here. 1.25. Listen, because this is her explanation.
Was another one of our residents at the time.
Was this order placed pursuant to your request?
Yes.
Okay. Well, why are you ordering seizure monitoring?
So we were trying to move Maya to a room that had a closed circuit video capability. So the name of those beds is our seizure monitoring unit. My concern in learning Maya, meeting Maya, and evaluating her, and also learning of other reports from colleagues and consultants in the case, was that Maya had repeated discrepancies noted in what she said she could do and what she would be observed doing when she wasn't aware that she was being observed, so to speak. So for example, and we may get to it, but there was a time where we'll ask her, can you move your legs? And she would say no. But then later that same day, I would see her holding her legs up in such a way and crossing her feet to where someone that can't move their legs would not be able to do that. So as part of my diagnostic evaluation and trying to really go through and do my due diligence to see what I felt her true underlying diagnosis and disorder was, I wanted to be able to observe her in a way, because there was differences in her performance when someone was a medical provider was talking to her and asking her questions and asking her to perform, and what she was probably doing, whether it was consciously or subconsciously, I can't say, when she wasn't directly being asked to perform.
Did you hear all the magic words? Did you hear all the magic words? For purposes of questioning the diagnosis and for diagnostic reasons, these are the magic words that have to be used.
So by putting her in that room with the closed video monitoring, we would be able to, for example, I wanted to know, like when she was sleeping, would she roll over in the bed? Would she be kicking and kind of moving her legs? Both of which are things that she would not produce for us voluntarily, but we were curious to know what would happen when perhaps she was either in the room alone or when she was sleeping.
Was your order for for the video surveillance for clinical and diagnostic reasons?
Correct. Yes, it was.
Let me ask
Leading.
this. The room that Maya was in before you moved her into the monitoring room,
Yes.
did that have cameras on the ceiling?
No.
Okay. So the general patient rooms do not have surveillance cameras.
Correct.
Do the general patient rooms have cameras?
No.
If I may approach, Your Honor, I was going to have the witness.
May.
Okay.
To show Mr. Whitney, since apparently this is his witness.
Mr. Whitney, you're up.
It's Mr. Whitney's witness. The judge making the comment is the judge acknowledging, oh, Mr. Whitney, okay, you're going to cross this witness. Okay, Mr. Anderson's been doing everything, but you get Dr. Dees.
Doctor, I've handed you what I've marked for identification as Defense Exhibit 3304-1. What room is this?
That's room 709.
Is this the room that Maya was moved into for the video surveillance?
Yes, it was.
Does this photo represent a true and accurate depiction of what the room looks like, with the exception of the bed?
Yes, I was going to say it, with exception of the bed, the crib obviously would not be in there for Maya. She would have had a regular hospital bed, but yes, the room otherwise looks the same.
Okay. In terms of the windows, the location of machines, everything else would have been the same back in 2016?
Correct. We have on the seizure monitoring floor, we have, I believe it's maybe 8, 9, 10 beds that are equipped with the remote video monitoring. They look like every other room in the hospital in terms of on the general medical floors. Of course, the ICUs and the neonatal intensive care units are a little bit different, but we often will have patients even in the seizure monitoring rooms that aren't necessarily being monitored because they function, look, feel exactly like all of the other rooms. There's no difference on the side of the patient. It's just more of whether we need that video monitoring capability or not.
Your Honor, I'd like to move into evidence Defense Exhibit 3304 and publish it to the jury.
No objection. Court receives Exhibit 3304.
Can we put that up on the screen, please? So you told the jury, obviously, well, what would be different from what the jury is seeing here for the video monitoring room versus how it would have looked? Was it the bed? Is that the difference?
Just the bed, correct.
Okay. And this would be the room that you had ordered Maya to be transferred to for video surveillance?
Correct. I didn't request like a specific room, but yes, we just requested for her to be moved to one of the rooms that had video monitoring.
Okay, we're going to fast forward jury questions, please. We get to all of, well, we're going to fast forward to cross. Whitney does cross. I want to highlight that. Lady Lysandra, thank you. 5K in chat. Hit the thumbs up. Please hit the like button, folks. Rob deserves it. I don't like family law, but I love torts, and you're doing a great. Thank you. Lady Lysandra, thank you. You've made several very, very generous and kind comments. Thank you for all of those. It is very much appreciated. Let's get into Mr. Whitney's cross-examination. I don't know why I said it that way. Maybe it was because I like the emphasis on the cross-examination. Oh, here we go. Are we before this? I think we're before this.
Not part of the treatment team.
Oh, here we go. Yep.
Dr.
Sorry.
Sally Smith, right? Findings or interpretation.
Itself,
Whitney does a
no.
great
However,
job.
there were other factors that I took into consideration.
You also understand that.
Gosh, Rob, come on. It's only 9 hours of stream. Why can't you find the exact timestamps you need? It's only 9.5 hours.
Discuss this case amongst yourselves. You did no investigation and received no information. Is that all? Did you see any media coverage in the last 5 minutes? Mr. Whitney, your turn.
Thank you, Your Honor. Afternoon, Dr. Dees.
Good afternoon.
You were previously deposed in this case. You recall that?
I do.
You do not have any expertise in complex regional pain syndrome, do you?
I am not like a registered expert, no, sir.
Yet you testified that under your assessment, you believed, your words, at the end, that Maya did not have CRPS. Is that right?
Correct.
When did you arrive at that determination?
I couldn't give you an exact date. I'm sorry.
Can't tell us which date?
There's no date that I decided that she did not have the diagnosis. I can say that by the end of the time I took care of her, that was my impression. Yes.
Your last interaction with her, if I was following, was November 1st or 2nd?
By the way, for those of you ever wondering how I cross-examine, witnesses, Mr. Whitney and I have the exact same style. We have the exact same style. I am not like Anderson. I'm not like Hunter. Mr. Whitney and I, exact same style. So I'm going to kind of not fanboy over this, but a little bit, because this is how I would have crossed Paula Dees. And I love the approach. Direct, pointed questions, not going all over the place, controlling the witness, keeping them in line, not sounding disrespectful, but being direct. Like this style of questioning, I loved.
I believe it was more like the 7th, I think.
All right, about 7th of November, that'd be the end of your time with her, right?
Correct.
So by that point, you'd reached an opinion that Maya did not have complex regional pain syndrome.
Correct.
As part of the treatment team. You were part of the treatment team.
I was part of the treatment team.
All right, so
correct.
the jury should be looking for bills for CRPS after November 7th, correct?
I don't understand your question.
Whoa, yeah, baby. Woo! That was a shot across the bow. Woo! So the jury should be looking for bills for CRPS after this particular date, which means after you reach the conclusion that she was not diagnosed CRPS, the jury should be focused in on these particular bills then. It was argumentative, but oh baby, wow. That was where I was like, oh, Mr. Whitney, you and I would get you and I would get along just fine. We would get along just fine. Oof.
I'm sorry.
Now, you understand that complex regional pain syndrome is not equivalent to paralysis, right?
Correct.
So the fact that Maya could move her legs does not indicate she does not have complex regional pain syndrome.
That in and of itself, no. However, there were other factors that I took into consideration.
You also understand that crossing your legs, a child crossing their legs, is the most comfortable, the most comfortable position for a child with CRPS. Were you aware of that?
I am not aware of that being a medical standard of comfort.
You've never talked to any physical therapists about that being a common position for CRPS?
I have never been told by a physical therapist that that is the most comfortable position for specifically a patient with CRPS.
All right. The 48-hour video that Maya did not consent to, that was for treatment, right?
It was more for diagnostic purposes.
All right. Where in the medical record are any notes concerning interpretation, follow-up, a report about what you learned during those 48 hours?
It was part of my overall assessment that was.
Oh, I love this. This is the best cross yet. This is my favorite cross yet. This is my favorite cross yet. Where is it in the notes? Anything documented about what you learned during this period? It was part of my general overall assessment. I noticed that you didn't say where in your notes any of this is. This cross was lightning. Like, this was how you cross a witness, especially when you don't want to alienate the jury.
Part of the factors that were taken into consideration.
Nowhere in your notes do you have any findings or interpretation of what occurred inside that room in 48 hours, do you?
There was notes made while she was in the room, yes, and observations that were made and documented, yes, while she was in the room.
Let's pull up exhibit 211, the text messages, 2116, please. And if you focus on the fourth text message there, if you blow that up for me. Just pull out the fourth text message and enlarge it, please. This is your text on October 19th to Dr. Sally Smith, right?
Yes.
It says staff has been making notes while watching her remotely, right?
Correct.
Why aren't the staff notes in the medical record?
Where are the
can't answer
notes?
that.
Where are the notes? Where are the notes? I can't answer that. You just texted Dr. Smith that.
We've never seen them. Have you?
No,
But this was for treatment.
no, it's for diagnosis.
Diagnosis as part of the care and treatment for Maya Kowalski while she's inside of Johns Hopkins Hospital.
Correct.
All right. And you're exchanging here text messages with Dr. Sally Smith about diagnosis for the purposes of care and treatment while Maya Kowalski's in the hospital, right?
Oh, the
Correct.
smile's gone.
But your position is Sally Smith is not part of the treatment team.
Dr. Smith is not part of the treatment team.
If you would please.
Yeah, you're on any approach.
Her tone changed real quick. Real quick. So, wow. We are now in this cross is effective. Do you see how quickly he went into it? Not dancing around, not a lot of what Anderson does. He came straight in, boom, 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 boom. 5 quick questions, good answers, get the points. You're making the points. Don't allow the extra elaboration. Don't go into it. Make the questions. And if she doesn't answer completely, leave that for the jury. Leave that for the jury. This is textbook cross. So long sidebar, they're going over chapter 39 issues. They want to discuss what he can and cannot say in front of this witness because he's going to walk this tightrope.
You may proceed.
We're going to come back to these, but if you could please publish 2277-0068. Dr. Dees, I'll represent to you. This is a note from the risk management file.
Objection foundation.
Oh, baby.
Take a moment to review it.
Even the time, take a moment to review it, giving her the time to review it. That gains credibility. I told you I'm going to fanboy over this cross. I gave you the warning. I'm sorry. I gave you the warning. I'm going to fanboy over the cross because the time to review it. I'm going to represent to you. This is a note from the risk management file. Give you time to review it. Long pause. Let her review.
Recognize your name on that note?
I do.
And who's the other physician there listed with you?
Dr. Smith.
And below Doctors Dees and Sally Smith, it says, okay from risk. Is risk management at Johns Hopkins Children's Hospital often making the diagnostic and treatment decisions for the patients?
No.
No?
No.
But you still maintain this is for care and treatment, this EEG video?
Oh, shit.
Yes.
What does it say there in the diagonal writing at the bottom right? Can you read that?
I have don't know. No was there 709.
Let me try. Able to
Yeah,
do
I'm
when
sorry.
no,
I've never seen this before, and it's not my handwriting, so I have no clue what that says.
there it is. Able to do when no one was there. Well,
Objection
You see that?
foundation.
Sorry.
Objection foundation speculation.
Overruled. You can continue.
Oh, it's not speculation.
709 was the
Read
room
it.
you put her in, right?
That was the room she was placed in, correct?
And this note here is consistent with your rationale, right? You
Able to do when no one was there.
were trying to see what Maya could do when no one was there.
I don't
709.
understand your statement. Could you rephrase the question?
Sure. You testified earlier that you were looking for inconsistencies and movements and things that Maya said she couldn't do, but she could do. And the thought was, if you put her in a room without
Oh my God. This is such great cross. This is so good. Why, Mr. Anderson, why have you kept this man from us? Why have you kept this man from us?
9 was the room you put her in, right?
That was the room she was placed in, correct?
And this note here is consistent with your rationale, right? You were trying to see what Maya could do when no one was there.
I don't understand your statement. Could you rephrase the question?
Sure.
God, why have you been keeping this man from us? I don't understand the question. Yes, you do. Yes, you do. Can you please rephrase? This is consistent with what you were trying to do, trying to prove. She was able to do these things when no one was there. I don't understand. Yeah.
You testified earlier that you were looking for inconsistencies and movements and things that Maya said she couldn't do, but she could do. And the thought was, if you put her in a room without telling her, you'd be able to see things she does when no one was there, right?
That is correct.
All right. You can zoom out for a second, please. And then October 18th and 20th, the third line down, it says on the right side there, I don't know if you can read that, it says to see if she can walk on her own.
Okay.
Consistent with the rationale you had for putting her in this room for 48 hours, right?
Presumably, if that's what that says, my reason for placing her in the room was not.
Ma'am, it is blown up on the big screen. I know that we stopped teaching cursive, but I also know that you're old enough that we know how to read this. To see if she can walk on her own. If that's what that says. Miss, I know that you can read this. I know that you've seen this before. I know that you were depoted
Not
on this. I
specifically
know
to
that you
see
know
if she
this.
could walk on her own. It was to see if she could perform any spontaneous movement of her lower extremities.
You thought putting her in a room under video surveillance that you would catch her doing something, not knowing the hospital's watching. True?
Could you rephrase that? I'm sorry.
You thought that by putting this 10-year-old girl in this room under video surveillance, you would catch her doing something that she said she couldn't do, but she wasn't aware she was doing while the hospital was watching her.
My intent when putting her in the room was to assess what she was able to do when no one was watching her. It wasn't in an intent to trick her or to
Is that a
catch her
yes?
doing something. It was to assess what her functional abilities were when she wasn't directly being asked to perform by a member of the medical team.
And yet in all the notes we looked at, there's no assessment following this 48-hour video, is there?
It is included in my total assessment, yes.
By saying no acute events overnight, that's it?
No, it is in my entire assessment of the patient. It is all part of incorporated in there.
What? So the generalized assessment is supposed to incorporate all of these specific observations, which are not specifically documented.
Let's go back to text messages for a second. Again, that's 2116. Let's look at the second page, text 15. If you'll pull out text 15 and enlarge it for me, please.
The pace of this cross. The
Here
pace
is Dr.
of this
Sally
cross.
Smith to you on October 21st, right?
Okay.
And it says, probably already in progress, but get her off as many, as a typo. Would you agree with me that meds was what is intended, as many meds as possible?
My interpretation, I agree with you that it was probably a typo, and that's probably what she was saying is meds, not mess.
All right. Removing medications from a patient. You'd agree with me that that's a treatment and care decision.
Correct.
Sally Smith's involved in this decision, is she not?
No.
She's not. She's texting you about it, but she's not.
Oh, this is the best cross ever. Oh, this is such good cross because it doesn't make sense to the normal person hearing the answer to that question. You would agree with me that removing meds is a treatment decision. Yes, I would. You would also agree that Sally Smith is directing or suggesting that meds be removed. No. You just read the text, probably already in progress, but maybe get her off as many meds as possible. Ice Guy, I'm sorry, this is a commentary channel, man. I am excited and I'm going to interrupt because this is a great cross.
Not involved.
She may have recommendations or suggestions, but ultimately the decision as to would be mine as the attending provider.
So you maintain, despite going back and forth with Dr. Smith on medications, that she was not part of the treatment team.
Well, as this text indicated, she suspected that we were already in the progress of doing it anyway. So she's just offering her opinion. She's not telling me what to do.
And you removed those medications too, didn't you?
The medications that were adjusted during my time as her attending physician were part of a discussion with an overall treatment plan and experts such as Dr. Hart, who is one of our consultants, our pain team, etc.
The answer is you removed her from medications during this time, right?
The answer is I would have to review the MAR specifically to know what medications were adjusted or at least refer to my notes.
All right, let's go to the next text message.
That would have yielded an objection that said asked and answered, but she didn't answer the question. So he repeated the question and says, you mean this? This is the best cross that we have seen this entire trial. I don't care if it's the plaintiff side, defense side, and I am just saying strictly 100% from an attorney standpoint, this is the best cross we have seen all of trial, the whole trial, the whole trial. So the pace, it's the pace, the questions, not lingering on a question. When she fights you on a question, make one more remark. The pace of this is quick, 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 quick. Make your points, get in, make the point, get out. Quick cross, direct from point to point to point. It doesn't have to be this long meandering thing where you're going through a bunch of explanation. If she doesn't explain it properly, redirect her. And I don't mean just her, any witness. And make the point, move on. If you get stuck in the weeds, get out of the weeds, move to the next point. Best cross, the whole trial. By far. Point made, move on. Point made, move on. Point, because the thing is, you focus on that text message about the direction of, what was the question? It was, you would agree with me that removing a child, removing medications from a patient is a treating decision, correct? Yes. You would agree with me that Dr. Sally Smith engaged in removing or engaged in a treating decision here? No. Don't go back and hammer that question over and over again. The jury can see the question themselves. You don't have to go all in at that. You don't have to make her conform to your line of questioning. Let the jury see that. They've been attentive. They are there. They're paying attention, man. They've got you. Just keep going point by point by point. This is the most effective use of time the plaintiffs have had this entire trial. This, out of the hour and 40 minutes that was used by the plaintiffs today, this, I think it was 10 or 15 minutes of cross, is the most effective cross-examination from the entire trial. The pace was phenomenal. Make your point, move on.
Message 16, would you blow that up for me? It says, yep, last med coming off today. Does that rest your recollection?
Yes.
You did remove medications during this time.
We did adjust medications during her hospitalization. Yes.
All right. If we could put up 1001-0426 again. And just note here, these text messages about medications were on the 21st of October.
Okay.
All right. No, 0426, please. Top line, Maya reported she's having pain all over.
Correct.
And this looks like October 18th. Let's go to 0421, please. About 3/4 of the way down, Maya continues to have pain all over. You see that?
I do.
And this note is from, if you could zoom out for a second, October 19th. If you could go to 0413, please. Complaining of pain all over, about 1/3 of the way down. You see that?
I do.
And this date, if we see it here, October 21st, the same day your text message, right?
Okay.
So you're moving from medications and she's telling you she has pain all over, right?
Yes.
Oh my God.
0409, please.
The inflection.
22nd, next day, complains of pain all over. You'd agree?
Yes.
All right. 0405. She is hurting a lot. See that?
I do.
The 23rd?
I do.
All right. 0369. You picked her back up in the first week of November, right? As a hospitalist?
Correct.
And here, what'd she say? Complains of pain all over?
Yes.
Can we please put up 2045-024? -024. You recognize the patient bill of rights for the hospital?
I do.
Would you please take a look at number 19 there? To the top right.
Yes.
Maya had the right to have her pain managed, did she not?
She did.
And she told you on 1, 2, 3, 4, 5, 6 different occasions as you were moving from medications that she had pain all over, did she not?
She did.
Who's Dr. Major?
One of my colleagues, one of the hospitalists.
She's a hospitalist on service with you, right?
She was.
And she was at the time of Maya's admission in 2016?
I don't know when she took care of her in the course of Maya's hospitalization, but I do know that she took care of her during Maya's stay at some point in time. Yes.
You worked with her
Yes.
and you traded off as hospitalist on rotation during Maya's admission to Johns Hopkins.
And she was involved at some point in time. Yes.
All right. Well, if we could put up 1002-006, which I'll represent to you as Maya's discharge note. And if you would please pull out the bottom paragraph there and the third line down, if you highlight it for me. What does it say about Sally Smith as part of the treatment team?
Doctor
Approach.
Okay, that's enough of cross. That cross was masterful. Masterful. I will tell you, for those of you who think that I am not being objective in my analysis of the lawyers in this particular case, I told you I'd be scared to go against Hunter because he's going to come at me with a bag of bricks. I told you that Shapiro is a style I don't particularly care for, but he does a good job. This cross, and I gave you the warning, I'm going to be biased about this because this cross is in line with how I cross-examine witnesses, because this is how I plan and lay out my cross-examination. It's just boom, 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 boom. It's beautiful. It's well-orchestrated trial practice. It was so great. The plaintiffs needed to do this. The defense has all the time in their hands. They have all of the time that they want. They really do. And they have witnesses coming up. Sally Smith, Kathy Beatty. I'm nervous about them for the defense's standpoint. I told you guys. I thought today was a good day for the defense. I thought it was a good day for the defense. They got their doctors and experts in. The only downside to the day for the defense was Paula Dees. She got shredded. Chat wants to watch a little bit more of the cross. Okay. Watch a little bit more of the cross, and then we're going to jury questions. You guys wanted more cross, and we got spinning wheel.
Dr. Major wrote that Sally Smith was heavily involved in her care, did she not?
That is what is documented, correct?
Should the jury disregard Dr. Major's testimony if they hear from her going forward?
Objection, foundation, speculation.
Oh, he won. He won the argument.
Those two I'm going to overrule.
This one. Argumentative.
Sustained.
I withdraw.
Number 3.
Yes, Judge. Okay, Shapiro. That's a funny moment in court. Funny moment in court. Shapiro goes, objection, foundation, speculation. The judge says, Mr. Shapiro, on those two, I'm going to overrule. Oh, God, it was great. Hang on. We're going to rewind. Play it one more time.
I'm going to overrule.
This one.
They hear from her going forward?
Objection, foundation, speculation.
On those two, I'm going to overrule.
This one. Argumentative.
Sustained.
Counsel, on those two, I'm going to overrule you. Argumentative. Sustained.
I withdraw.
Number 3.
You can take that down, please. All right. No further questions this time.
I'm sorry.
Oh, yeah, you're right. Sorry.
So it's Mr. Shapiro's turn?
Yes, Your Honor.
Thank you, Mr. Shapiro. Why are you reducing medications for Maya? Pain medications.
That's a great question. As we discussed previously, there were a lot of inconsistencies with Maya's reports of her symptoms, with what she said she could and couldn't do versus what we would objectively observe. When you think of someone that is experiencing 10 out of 10 pain, all over pain, it would be exceptionally uncommon for not only days, but weeks in a row to have that sustained level of pain to where you are simultaneously calm, smiling, playful. So although I absolutely agree, and I'm very passionate about ensuring that our patients have their pain well controlled, we have to have an indication to treat them and their pain. So we don't use, morphine or ketamine or Dilaudid, these big, strong narcotic pain medications, for example, for a scrape, right? We have to assess the patient's reported level of pain against the objective information as to why they would be in that type of pain, and then select pain medication that would therefore treat that type of pain. So because we did not feel as a medical team that Maya's condition was consistent with CRPS, there was not an indication to continue to escalate her pain, especially when she was not observed, at least I can only speak from my own personal experience, having any type of outward demonstration that she was actually in significant pain. I've treated, I don't know an exact number, but thousands of patients over my career. And when we're...
Let me redirect this. The decision to start and stop pain medicine,
Yes.
was that made by you?
That was made in collaboration with our pain specialists and physiatrists. Yes.
And the pain specialists and physiatrists, those are the all children's employed pain specialists?
Yes, sir.
Okay. In going through the chart, have you seen a single order from Dr. Sally Smith in that chart?
No.
So if the jury goes to the medical record of all children, they're not going to see Sally Smith's ordering anything for this patient. Is that right?
I obviously would have to review them all personally, but I am not aware of her entering any orders directly in this case.
Why are you communicating with Dr. Sally Smith?
So Dr. Smith is the only child abuse expert and is the medical director of the child protection team in Pinellas County. She is our expert. She is the only one. I would be committing malpractice if I did not communicate with her.
Ooh, this is a problem because this makes her very much kind of part of the treating team. She is just saying on behalf of the hospital that she is required and must involve her in these discussions. This is a tough part. Shapiro did a great job on redirect. This is one where Paula Dees, based on the cross, got a little bit over emphatic in her response. This might be a problem. This might be a problem for the hospital.
Her as a specialist, in addition to me being legally obligated to cooperate with her and communicate with her on this case.
So let me ask you about that. Is it your understanding that you have a legal obligation to talk with Dr. Sally Smith if she requests your input?
Objection calls for the conclusion. She can answer that question.
100%.
Okay. Couple other questions. You were asked about whether the EEG, the surveillance room, gave you any information. Was it significant to you to look at the video and see whether Maya could tolerate a blood pressure cuff?
That was. I can answer. Okay, thank you. So those accounts were passed on to me. Yes, that there were things like, for example, her being able to tolerate blood pressure readings, her being able to tolerate transfers, her being able to tolerate playing, touch with play, moving her legs. All of those in totality were all considered as part of our overall evaluation and treatment of Maya.
Why isn't Maya's name on the door?
You mean like in terms of a placard
Right.
under the room
On
number?
the outside of the door.
Okay. Nope. We're pulling you down. I'm not going to do you dirty like that. Nope. We're going to go to the jury questions. And I do want to bring this up because I saw comments floating around. Ash, Nicole, Jules, I don't think you're doing anything wrong, but maybe if Rob clarifies it, people stop saying it. Jules is in court every day. Courts are public. They are public. I'm actually about to show you a part of court that's public, and a lot of people have a lot of misinterpretations of this. There is nothing wrong with people observing something in court and giving commentary on what they observe in court. That's what news reporters do. That's what the freedom of the press is. We have reporters that go in and observe court, and they come back out and write articles about what was observed in court. They write articles about how the jury perceived things, what the witnesses said, how the room felt and sounded during that period of time. Those reporters actually talk to the parties. They talk to the attorneys. They talk to the witnesses. They talk to everybody. They really do. They go and they talk to all the people, and they say, Chanley Painter. Great example. Chanley Painter for Court TV was watching the Depp v. Heard case. I was there, talked to her a bunch. She's a reporter. She talks to the witnesses. She talks to the parties. She talks to the attorneys. She talks to everybody. She observes what happens in court. She goes on Court TV and talks about what happens in court. She talks about her interviews with the attorneys. She talks about her interviews with the bystanders, the people that are watching. They're allowed to do that. There is no distinction between reporters, people that have the badge, and people that are allowed to observe as the public at large. In the US, freedom of the press extends to everybody, period. So you're allowed to go in and talk about what you see. And you can actually talk about what the makeup of the jury is. You can talk about, how many times have you seen Chanley Painter and other individuals say the jury makeup is 5 males and 4 females? And you're allowed to talk about this stuff. You just can't give personally identifying information away. You can't say that the juror's first name is Paul, or that he drives a Honda Civic with a license plate blank, 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 blank. You can talk about who they are. People that go into that courtroom can go and look and see that jury for themselves. If you want to fly to Sarasota, you can walk in that courtroom and look right over there and say, cool. Hi. Hell, we know one of them had a birthday because the court announced it. So you're allowed to do these things. I have listened to Jules's commentary, and I've been talking to Jules about this, and she hasn't stepped a foot out of bounds. She's been very careful not to step a toe out of bounds. She gives her impressions of what she thinks the jury is perceiving in that moment. She might be wrong, she might be right, she might be any number of things, but what she hasn't done, she hasn't gone out and say juror number 5 is named Bill Nye the science guy. He is a master of science and he does all the science things, and this is his license plate and where he lives. No. You're allowed to say these things. Public forum. Public forum. That might make people uncomfortable, but that is the truth of the American judicial system and how we try these civil cases. So, yeah, Jules is fine. What she's doing is completely fine. Completely fine. Permissible by under the law. I absolutely fine. There's nothing wrong with that. Just like me giving commentary on what's taking place in trial. Just like this other person I'm about to pull up, because you know what we're going to do? We are going to...
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
Thank you, Emily. Thank you, Emily, for that. That's much appreciated. The reason why I do that is because, and I make that prefatory comment, because there's another person that's been live streaming this trial who actually applied and requested access to the Zoom feed for court. And that's my friend here, Scott, recovery addict. So the Zoom feed is public access. You have to apply to get it. Like, you just have to get vetted. The judge just wants to make sure that if you're in the Zoom feed, you're there with a legitimate reason, but anyone can do it. You don't have to, because the court TV feed is there too. Okay. But the Zoom feed, court TV cuts the mics, and the Zoom feed continues because the judge has control over the microphones up there at the bench. You're allowed to see and hear these things. You are. The judge has deemed it so. This is permissible. This is allowed. So the jury gets excused and the lawyers get to question, because now we have the jury question to pass up the judge, and the judge is like, that's a lot of questions. You guys get out of here. And recovery addict has the Zoom feed. And he's allowed to do this. He's not allowed to broadcast the feed directly. Can't rebroadcast the feed directly, but just like a reporter, just like an announcer, you can hear what's taking place and you can give commentary on what's taking place. The judges approach the bench. The attorneys have come up there. They are looking very anxious and nervous about these particular questions. The judge begins reading from one of the questions. The question is asked. You're allowed to do that. Fair game. Because court is public. It is public. So let's listen in the sweet, buttery voice of recovery addict, who is covering this daily and is watching this live. So if you guys wouldn't mind, if you jump over and say hi to him tomorrow or the next day when he's covering this live, make sure to tell him I sent you. We're going to get him to 50,000 by the end of this trial. Let's listen to jury questions as discussed by the attorneys.
Side.
Dr. Dees is out of her presence. Let's go through this. There's a whole bunch. Red number 1. Did you testify that it was your idea to place Maya under video surveillance? 2. Why did you ask Dr. Smith how long she wanted to keep Maya on video? It was part of the text messages. 3. You also texted Dr. Smith asking her if she wanted to review camera footage from Maya's surveillance. Why? No objection, says both parties. Red number. Judge says, sorry. It doesn't have to be unanimous. Just one member of the team. Okay. Red number 2, says the judge. Who is on care team with you? Does CRPS pain change daily? No objection, says Shapiro. No objection, says Anderson. Red number 3. If Maya complains about having pain all over, how does Maya dress herself? No objection, says Shapiro. Judge says, just say it a little louder so I can hear you. Number 4. October 18th progress note. Why is pain, quote, all over, in quotes? Were you presupposed to doubting Maya? How many CRPS patients, pediatrics, had you treated before Maya? Number 3. How many CRPS PD patients have been treated at All Children's Hospital before Maya? A lot or a few?
Red numbers. People have asked this question. The judge explained that he designates at the bottom of the page, he says red numbers. The red numbers is how he designates the questions being read out loud. So that's how he designates it. It doesn't mean anything one way or the other. They're all red number. They are red number, red number, red number. It's how he designates jury questions.
Few. No objections from either side. Red number 5. And there's a whole bunch on this one. Would you be willing to admit that sometimes staff in high-stress service jobs develop family-like relationships, supportive of one another as the work is arduous and prolonged? Number 2, All Children's Hospital has had a number of long-term staff members and even some service members who seem, parentheses, to have deep roots in All Children's Hospital. How would you describe these relationships as, quote, almost familial, end quote? Did you observe Maya being denied religious ceremonies?
Yes, READ.
Did you ever
read out
hear
loud.
about Maya requesting religious ceremonies? Number 4, is it within normal expectations that most kids struggle to eat hospital food? Did Maya struggle to gain weight and consume desserts? Next, 5, what kind of oversight do the hospitalists have over Kathy Beatty's position, if any at all? As the coordinating hospitalist, does your work require you to interact with her? 6, is a child's overall treatment at the hospital have an effect over their recovery and length of treatment in your experience? 7, what floor did your work take place on? Who was the Kathy Beatty of that floor? Did these positions normally, quote, stick to a patient on multiple floors, end quote? Carell says, we're going to need to see that. And judge says, well, you got it. Hey guys, no personal attacks, please. Shapiro says, we object to the statement of number 1. Will you be willing to admit that sometimes? As to the other questions, they're still looking at them. We object to number 2. Whitney says number 2 is asking about the familial relationships. I mean, they're exploring the relationships in the hospital with Sally Smith. That's fair. Carell says that's a statement. Shapiro says number 1 is supportive of one over prolonged. Everyone's talking at the same time.
All right, so I'm going to pause that there for a second because I'm not going to give away his whole thing. If you guys want to catch him doing his live coverage of this case, please go check out his channel, Recovery Addict, on YouTube. He does have access to the Zoom feed when the questions get asked. He has attention right there on that ear, man, and he gives you the information. It's invaluable. But I don't want to prolong just listening to him talk about it. What I want to hear is the actual jury questions, and then we're going to get out of here. So make sure I've got my timestamp right. Get the right moment pulled up. 84541. Second. Okay. Please go check out his stream. He's done phenomenal coverage. He's been remarkably respectful. So please go do that. Tell him I sent you. I love that he says thank you every time when he sees someone pop up from my chat. Like they're not the best people in the world. Like you guys are amazing people. So I'm not surprised that he's happy seeing all of you there because you guys are amazing people. Just remind him that you guys are amazing people and that we're all the good group of bunch watching this particular trial. Okay. After this, I'm going to have to do a quick summary of the chats. I'm going to start pulling up super chats while this is playing, the ones that don't have questions, because I need to give my mods a break because they've been going for 3 hours on a weekday and it's late. And it's my fault. It's not their mods. You guys are amazing, 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 amazing.
Mr. Altenburn, is Mr. Elegant going to be joining us somehow? Or?
No, wrong.
All rise, or is that correct?
Okay, yeah, right. Okay, good.
Okay, everyone, please be seated. Members of the jury, just want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and did not receive any information. Is that correct? No one approached you and didn't see anything about the case, correct? Okay, Dr. Dees was out of our presence, so this will be the first time she's hearing these. There's a number of questions. Did you testify that it was your idea to place Maya under video surveillance?
It was my decision, yes, to move forward with the video surveillance.
Why did you ask Dr. Smith how long she wanted to keep Maya on video?
That wasn't the question. That wasn't the question. Was it your idea? It was my decision. Those are different things.
Dr. Smith also had recommended video surveillance for her kind of, I guess, forensic or legal portion of it. And so I had reached out to RISC because I was unfamiliar with that portion of it. Certainly it made sense to me for us to both complete our portions of our investigations in a kind of coordinated and simultaneous way rather than like moving her back and forth. So that's why my portion, I felt that I had enough information to help me with my decision making, but just needed to ensure if she was also done or if she needed more time for the legal portion of it.
You also texted Dr. Smith asking her if she wanted to review camera footage from Maya's surveillance. Why?
Because she had requested the surveillance as part of her legal case and forensic case.
Who was on the care team with you?
So those would be internal providers at Johns Hopkins All Children's Hospital. So everyone from myself, my consultants, my residents, our nurses, our physical therapy, occupational therapy, pain team, all of our internal providers that were part of her care team.
Does CRPS pain change daily?
Presumably it can, of course, yes.
If Maya complained about having pain all over, how does Maya dress herself?
That's a great question. I can't answer that on her behalf.
The October 18th progress note. Why is pain, quote, all over, end quote, in quotes?
So when we're teaching our residents about involvement in cases that are, child abuse, medical child abuse, neglect, sexual abuse, things like that, where we understand that there's a high likelihood that there will be court proceedings, legal things, we try to explain to them that it's important to not interpret a patient's symptoms and document their interpretation of the patient's symptoms, but to simply ask them the question and then put their response in quotes, because we want to make sure that we're not changing what the patient reports and that we're just factually gathering that information and then reporting it as they've stated it.
Were you presupposed to doubting Maya?
No.
How many CRPS patients, pediatric patients, had you treated before Maya?
I don't have an exact number. I would say it's hard to kind of extract the past 6 years of experience that have passed, or 6, 7 years. I would say at least a handful at that time, if not 2 handfuls, but it's kind of maybe 5 to 10. I'm not exactly sure, but more than just Maya, certainly.
How many CRPS pediatric patients have been treated at All Children's Hospital before Maya?
I don't know the answer to that question. I'm sorry.
Next question. Would you be willing to admit that sometimes staff in high-stress service jobs develop family-like relationships, supportive of one another as the work is arduous and prolonged?
That is certainly a possibility. Yes.
All Children's Hospital has had a number of long-term staff members and even ancillary service members who seem, parentheses, Sally Smith, in parentheses, to have, quote, deep roots, end quote, at All Children's Hospital. How would you describe these relationships as almost familial?
I'm not sure I'm understanding the question. Is the question asking that there have been a lot of staff members that have had longevity at the hospital, and how do we interact with each other as a family? I'm sorry.
I think for follow-up, if the lawyers feel they need to, or if the jury feels they can follow up, they can, but I'm just reading it as it's.
Do you mind repeating it to see if?
Sure. All Children's Hospital has had a number of long-term staff members and even ancillary service members who seem, parentheses, Sally Smith, in parentheses, to have, quote, deep roots, end quote, at All Children's Hospital. Okay. How would you describe these relationships as almost familial? Or maybe would you describe these relationships as almost familial?
I can only speak from my personal experience being a physician that not only trained as a medical student, I did a rotation at All Children's, then completed my residency training, then have stayed on as an attending. From my own personal experience, I can't speak to Dr. Smith or on behalf of other members of the medical staff. Some of my very best and dearest friends are colleagues, absolutely. One of the things I'm most proud of working for Johns Hopkins All Children's Hospital is the caliber of physicians, nurses, consultants, team members that work in our institution. Everyone is committed to taking care of kids, doing it in a high quality, evidence-based and compassionate and family-centered way. We definitely all support each other and are there for each other. But I have never had concerns about boundaries of personal relationships compromising our professional integrity or compromising our ability to remain objective in the face of a challenging case, for example. So I hope that answers your question.
Did you observe Maya being denied religious ceremony?
No, never.
Did you ever hear about Maya requesting religious ceremonies?
No, not to my recollection, no.
Is it within normal expectations that most kids struggle to eat hospital food?
Well, so in theory, hospital food usually is thought to be unpalatable, but I do think that we have, we're a pediatric hospital. We're pretty friendly towards, we've got ice cream and milkshakes and cookies and stuff like that. It's not like, I guess, what you would see on TV where it looks like a TV dinner and it looks like it's this frozen, horrific reheated mess. So absolutely. Are there some kids that don't like our food? Of course, right? I mean, everybody has their own personal preferences, but have I seen kids order SpaghettiOs and Pop-Tarts for breakfast and they're sitting there eating it like it's the best combination and I'm sitting there nauseous because I don't understand how they could possibly eat that combination of food? That too, right? So it just depends. But, each case is so different and each child is so different. So it's kind of hard to make a global assessment of that.
Did Maya struggle to gain weight and consume desserts?
I don't know about desserts specifically. I remember she was eating a lot of graham crackers from my notes, but I don't know specifically more than that about desserts. There was a history of struggling to gain weight, but she did have improvement in her weight during the hospitalization.
What kind of oversight did a hospitalist have over Kathy Beatty's position, if any at all?
So the social work department has their own reporting structure, and we are not responsible for the oversight of their standards of care, professionalism, conduct, proficiencies, et cetera, anything like that. They are certainly the social workers are an invaluable part of our teams, but we don't have a direct responsibility to monitor or evaluate or ensure their practice standards, if that makes sense.
End the night.
As the coordinating hospitalist, did your work require you to interact with Kathy Beatty?
Yes.
Does a child's overall treatment in the hospital have an effect over the recovery and length of treatment in your experiences?
Do you mind repeating the question one more time, please?
Sure. Does a child's overall treatment in the hospital have an effect over their recovery and length of treatment in your experience?
So that's a difficult question to answer because there's so many different diagnoses that I treat as a hospitalist. So I can treat anything from asthma to pneumonia to seizures. I, on a daily basis, treat kids with multiple chronic medical conditions like cerebral palsy and, dysphagia, to where they have gastrostomy tubes and feeding tubes. So it's really hard for me to think of all of my patients as one to be able to answer that question, because there are some kids that absolutely without coming into the hospital would not get better on their own, right? And so I feel like we help them recover more quickly. There are certainly, I'm sure, some cases where there are prolonged hospitalizations, that dynamic, being away from families, which of course is stressful and hard, being away from their support networks, that I could definitely foresee where there are situations where maybe that could impact their path to recovery. But overall, of course, and that's our job, is to try to help them. We want them to get better and to get them back home or wherever it is that they came from. Some kids come to us from skilled nursing facilities and we send them back there. But our goal is to get them medically stabilized, make sure that there's no longer need for acute inpatient services before we transition them back to where they are, so that they can continue to thrive and do all the things that we love to see kids doing.
Next question. What floor did you work on?
Okay. That's it for the good doctor. That's it for the good doctor. So let me remove the banner, because we're going to catch up on some of these chats and we're going to get out of here, because I wanted to land this thing at 2 hours. I knew that today would be longer because experts and that cross. But I'm sorry for how long the stream went. I'm actually really, really, really sorry to the mods. That's what I'm sorry. I'm sorry to the mods. I'm sorry to my mods. I keep you guys here way too long. I'm sorry. It's my fault. The plane, it flies, and I try to land the flying plane, and the squirrels attack the brain, and I'm sorry. Sorry to my mods. So we could review that for hours, but I need to get the recap kind of concluded, and then we can resume tomorrow. Okay. Jen Goods, thank you. CPT codes don't CPT. Let me rephrase this. Jen Goods, thank you for the very generous super chat. CPT codes align with diagnosis. And even though they are different, doctors know, first comes diagnosis code, which justifies IP stay. Then comes CPT code, which aligns with LOC. You can only apply an IP CPT code, inpatient CPT code, with a qualifying diagnosis. Saying you need to know the CPT code is BS. There's a lot of translation that I'm sure medical professionals in the chat will understand. My reading of this is that when they're billing for it, and it shows as a diagnosis code and a CPT code for billing, that they should align. I could be wrong. Jen, thank you for the very generous super chat. I hope that made sense to a lot of people in the chat, because I'm still struggling, but maybe it's also because I've been streaming for 3 hours after a full day. It's my fault, not yours. My fault, not yours. Irene, thank you. Since the attorneys can't prep the witnesses, can they be prepped by another external entity? The attorneys can prep the witnesses. They're allowed to prep the witnesses. They're not allowed to coach the witnesses to tell them what to say or not to say. They're allowed to prepare them. They're not allowed to speak with them in between their testimony. They can't influence how they are testifying once they take the stand and start testifying. So that's how they go about that. Kristen, M96, what time Saturday? We have not decided. I will probably announce that tomorrow. Megan Brogdon, thank you. For many international viewers, Australia here, what time Saturday? I'm going to announce that tomorrow. Got to plan accordingly, since it'll be Sunday for me, most likely. I will announce that. I'll try to coordinate with Spidey tonight. Brianna Pinckney, because of your channel and Emily, I think I'm going to take the plunge and study for the LSAT and go back to school for forensic linguistics and law. Brianna, good for you. Good for you. I wish you all of the best of luck. I promise sincerely, if you love the field, you will do wonderfully in it. Gingy Probs, question, in your opinion, do you think J. Hatch attorneys know they've lost this jury but aren't offering settlement because they're banking on appeal? No, I think they know that it has to be unanimous, and they're banking on one or two of the jurors. Happy Fun Casino Time. If he is paid $750 per hour and has billed $25,000, it's 33.33 less, 33 hours, less than 33 hours for all of this history. No, I think that there's probably some of that that's pro bono, probably some of that he hasn't billed for. He hasn't done his final invoice, so we'll see. Laura Robichaud, Rob What do we do when we're out of time? Are we just out of luck? I think we only have 7 to 8 hours left. Sally Smith comes Thursday, BD Monday. That was something I didn't make a comment about. The plaintiffs burned an hour and 40 minutes of time during cross-examination of the witnesses today. Dr. Paula Dees, I think, consumed maybe 15 minutes of cross. That's why I like Whitney's style. Make the points, get out. Whitney needs to handle cross for a lot of these, and you have to prep the cross. Because you're going to have to pass on witnesses because you need rebuttal. You need rebuttal. If you're out of time, you're out of time. Now, I talked to Peter. Peter doesn't think the judge is going to just let him like squander and say you're out of time, you can't do anything. And I'm inclined to agree, but he's going to start cutting him short real quick. Trimming the sails. Peacock, what was the significance of his notes that he was reading from? I was working and I missed it. At the conclusion of Dr. Crane's testimony, there was a hubbub about the notes that he was referring to when he was on the stand. And what that is that's for demarcation. So that gets marked, not entered into evidence, but gets marked and scanned by the clerk. So the clerk knows in the eventuality of an appeal, the clerk has a record of what was being referred to when the witness was on the stand. That was the hubbub about that. JT, first, thank you for what you do. How hard do you think it is for the Judge C to rule on points made by a veteran of the appeals bench like Altenburn? He's been doing good. He has. He has been pushing back a lot, and he has said, we will disagree on this. He has said openly, we are going to disagree on this. I get your opinion. We're disagreeing. I'm making my ruling. Moto 88, how can they sue for Beyonce's death and not get into her mental health, including Munchausen's by proxy in the police and CFS investigations? I'm confused. Moto 88, they're allowed to get into it to an extent. It's a fine line they have to walk, and they're walking it very carefully. Manders 13, that's at least the fourth witness that said, a good question. Do you think that's a purposeful to endear them to the jury? Somewhat it is. It also buys time. It's a time buyer. If someone asks me a question that's really hard, I say, that's a good question. It buys me the extra seconds to think my way through the answer. It also endears me to the jury. At least we think so. I think the jury is after this many witnesses are saying it, they might start to feel it as condescending. So I would just start answering the questions. Just my assessment. De novo, would asking the witnesses if they personally experience chronic pain be allowed in? Thinking biases. No, their personal experience isn't coming in. Nope. Because that is separate and apart from this particular case. Peacock, thank you. Hi, Rob. Not sure if you got my last chat. What was the significance of Dr. Crane's notes? I did, Peacock. I read them. I'm sorry that I missed the first one. I do save the question ones, and I try to hit them at the end. AG, thank you. In your experience, how much does the appearance of a witness after how juries view them, even if otherwise credible and qualified? I agree it shouldn't matter, but it does seem to anyways. Yes, the appearance of a witness, their mannerisms can affect how the jury perceives their credibility. It shouldn't, but it does. For example, a witness that might look down all the time, they might view them as being evasive. We saw this with the plaintiff's witnesses. They had one or two that were back and forth a bit. I think Dr. Chopra was a big risk. Dr. Chopra was a risk. I think he sold well, but that to me as an attorney would have red flags all over if I had a witness that was doing that. Joking remarks that were sarcastic. That can really sway how a juror views the information. And there might be jurors that are on that jury right now who are looking at Dr. Chopra and the jokes that he was making and looking at Dr. Krane and how serious he was and saying, well, Dr. Chopra was being joking and Dr. Krane was being serious. I'm going to weigh Dr. Krane more heavily than Dr. Chopra. That might be the case. So it impacts how the jury perceives it. Gingy Probs, it doesn't help at all that you can clearly tell when these docs get angry as if they're personally affronted. If this was about Maya, I think it would be less obvious when their egos are bruised. If I was a doctor that was doing my best, for example, if I'm a lawyer in a lot of cases, if I'm a lawyer that's doing my best to protect my client and I have someone that's attacking me for decisions that I made in their litigation and saying it wasn't, and I believed full-heartedly that what I was doing was advocating responsibly for my client and doing my very best. And I have someone on the other side cross-examining me and pointing shots at every decision I made. I would get defensive too. That's why I'm kind of trying to show them grace. I would get defensive too. Aaron, I can't stick around any longer. Your chat is so polarized and lacks any sense of objectivity. They're slanted one way. They're slanted strongly in one way, but there are a lot of people that are listening to all of the evidence, and there's a lot of people who express some very firm opinions in the opposite direction. And I try to highlight both of them. I really do. Objectivity plus understanding is why I love LawTube. I try to give that. I do my very best. I might fall short of that, and I apologize for falling short of that endeavor, but I do try very hard. Aaron, you should check the response to my last super chat. I'm sorry that you felt that way. I truly am. I try my hardest. Deb D, I'm a CASA, court-appointed special advocate, on a Munchausen by proxy case now. Super hard. MDs like this make our job harder. They need to be 100% on their game with files and notes, get their stuff together. Those kids need it. This is a case gone wrong. Deb D, first, thank you for what you do. It is a very tiring job that does not get a lot of accolades. I appreciate the hell out of that job. Thank you for what you do. 2, yes. And 3, doctors and treating physicians, nurses, individuals need to listen to people that are court-appointed special advocates, guardian ad litem. Listen to these people who are telling you, if you want me to get involved, you have to give me these documents and this information. JM, stupid question. How can he plan a cross-examination before he's on direct? He asked things they didn't address. Oh yeah, we plan cross from the minute that we have that witness and with the minute we know what they're going to say. You have to anticipate what they're going to say. You have to. And it's not about exactly what she testified to. It's the subject matter she went into. Dr. Sally Smith. That opens the door. He knows it's going there. So he's going to prep his cross ahead of time. Chris Cat Queen, Dr. Dees made a good point. If you're thinking child abuse, Munchausen by proxy, then you have to involve Sally Smith as a consultant. So technically she had to be a part of the treatment team. Either way, Jay Hatch is screwed. Interesting observation. Gabby, thank you. Doctors have hugely onerous, important jobs, but these seem unaware that their authority had limits. That same groupthink is a frightening combo. I have concerns about how the medical field, the medical bureaucracy treats patients. Jen Goods, yes, the diagnosis code must align with the services you're going to give in the LOC, level of care. Thank you, Jen Goods, for the clarification. Very much appreciated. And then Lynn 2574, if Jay Hatch offered a settlement now, would we even know about it? Nope. And you shouldn't. And we shouldn't. So that's where we're going to leave you this evening. Thank you to my mods. Thank you to all of you that are here. For those of you asking for the subscriber update, because I know that you have been, we are at 199,538 subscribers. So thank you all for being here. Thank you for choosing to subscribe. Thank you for liking the video. Please, please, please. If you think, let me do this. I want you, well, I want you to step outside your box. In the comment section, I want you to make a comment about what you observed in testimony or evidence favorable to the side that is not the one that you feel should win. Tell me what it was. Tell me what the most impactful thing that you heard from the side that is opposite of your own perspective. Just tell me. I want to hear it. So tell me what was most impactful about the side that was opposite of where you're leaning. And I'll read them before tomorrow. I will. For those of you who gifted memberships tonight, I know they got pulled up on the screen as I was going along. Thank you. The contribution to the channel is so very much appreciated because the memberships to this channel, I'm going to go into the shop for a very long period of time after this trial, and we're going to have a lot of member streams that are very private with just us hanging out and building stuff. So thank you for tolerating me while I do these Maya recaps. I very much appreciate it. You guys are the best. And thank you for growing the community. Thank you for communicating respectfully. Thank you for all the love you show my friends on YouTube, whether it's Runkle of the Bailey, Kurt on Civil Law, whether it's Peter Tragos, lawyer you know, or Emily D. Baker, or the person I got to shout out the most is Recovery Addict, who's done a phenomenal work at covering this trial. Phenomenal work at covering this trial. Please check out his channel tomorrow during live coverage. Tell him I sent you. Thank you guys very much. Good night, and I hope you enjoy the outro. Go make something. You'll feel better. Night, guys.